before we want to get to the debt. You have to understand how they see it, how they operate. Once we understand how they operate, you'll realize that in many cases, the debt that they're already trying to collect from you is a debt that they already. A lot of the balances, look at your contracts, they remain in balance. It's never what's actually booked. You ever looked on TILA, page 2 of your contract? You ever notice that what's going on before we want to get to the debt? You have to understand how they see it, how they operate. Once we understand how they operate, you'll realize that in many cases, the debt that they're already trying to collect from you is a debt that they already. A lot of the balances, look at your contracts, they remain in balance. It's never what's actually booked. You ever looked on TILA, page 2 of your contract? You ever notice that the itemization, that number is always low, and then when you get to the finance charge, it's always a bigger number? Isn't the finance charge supposed to be disclosed? The items of the finance charge supposed to be disclosed on TILA? But you know it's on page 2 or whatever the page, your itemization. It's always some amounts paid to others on your behalf. It's always a low number. But then you look back at your finance charge, when you subtract that low number from the finance charge, you'll be like, well, where the rest of this money at?
Online, you will hear the terms accounting, ledger, books, and GAAP. The new culture has actually broken down the deep layers of advanced accounting, had his interpretations confirmed by top professionals in that field as well, which allows him to see beyond the face of the contract to find the hidden figures. There is no contract that is subject to securitization that he can't find the hidden figures. If you look around, everything he brings to this space is groundbreaking, insightful, and in many cases will be the first time you ever heard of it. He is often imitated but rarely duplicated. He is and will forever be the blueprint.
I never thought I'd see
You're rocking with the best.
a time when you would be so far away from home, so far away from me. Just think of all the moments I'm wishing on a star.
You're rocking with the DJ that keeps the hits coming.
You are wishing on a dream to follow what it means. I'm wishing on a star.
You're rocking with the best.
Follow where you are. I'm wishing on a dream to follow what it means. And I wish on all the rainbows.
Breaking off another hot explosive mix.
I wish on all the people who really dream. And I'm wishing on tomorrow, praying it will come. And I'm wishing on all the loving we've ever done. I never thought I'd see a time when you would be so far away from home, so far away from me. Just think of all the moments that we spent. I just can't let you go for me. You were meant, and I didn't mean to hurt you. But I know that in the game of love you really.
You're rocking with the best.
I feel it's time we should make up, baby. I feel it's time for us to get back together and make the best of things, oh baby, when we're together.
You're rocking with the DJ that keeps the hits coming.
I feel it's time we should make up, baby. I feel it's time for us to get back together.
rocking with the best.
Whether or never.
I know. This is going to start to be the new introduction for me. I know. Nevertheless, you are back in the building, and we got something. I really didn't want to talk about it, but I feel like we got to talk about it because this is only going to help you. This is really going to help you. Now, we have a situation that we have to address. And the situation that we have to address is I'm already understanding that a lot of pro se litigants are utilizing ChatGPT. I know that a lot of pro se litigants are going to continue to use ChatGPT. I know a lot of things that you may hear me say, they're going to run it through ChatGPT. But here's the thing that makes that kind of dangerous with using ChatGPT or other artificial intelligence to actually format your complaint, draft your complaint, give you case citations. There is no artificial intelligence out there that's going to replace what the human brain can do. I'm pretty sure y'all heard studies. The human brain is still one of the most intriguing anatomies of the human body. It's still not fully discovered. It's still not fully understood. And when it comes to court and litigation, regardless of what AI apparatus you use, you must still have a full understanding of the things that AI can't give you. So and a lot of things you can do by yourself. You really don't need AI for the most important parts. You don't need AI to actually help you win the case or put you in a position to win the case. You can do that on your own. It takes time. It takes dedication. It takes discernment. It takes wisdom. It takes proper interpretation. It takes a lot of things, but you can still do it. So we're going to read this case first. We're going to get to the report. And coming today, we have another report, another newsletter that's going to be available. Join the Patreon. If you haven't joined the Patreon, link is in the description. So this was a court of appeals out of Atlanta, Georgia. Hopson. Oh, her name gives me trouble. Taffeter. Taff. I'm just going to call it Taff. Taff Hopkins. Proceeding pro se. This is one of the things that the courts are not going to say. And this is one of the prejudice nature. It's quite prejudice to the defendant or plaintiff when they see the term pro se. Here's some of the uphill battles that you got to get through as soon as you slap pro se next to your name. They automatically assume that you owe on the debt and didn't pay. If you're getting sued, they automatically assume that you don't understand the court rules and procedure. They automatically assume that you don't understand proper application of case law and how to cite case law. They already think just because we didn't go to school, we didn't get a license, We're too dumb to actual deal with court. That's what they think about us. And to be honest with you, I truly believe that most of us are smarter than them. They think that because they have a certificate or a degree that makes them superior. Do not allow them to have you thinking or approaching things from an inferior position. Don't tell yourself it's too overwhelming. I can't do it. I was not going to win without. Don't, those self-defeating words, when it goes to court, you have to put all that crap out of your head. I didn't know anything about court when I first got started. Years ago, I had to learn by getting my head smacked over the white meat. Like push back. But the more I kept shooting at it, the more I kept doing it, looking at what I did wrong then, applying those lessons now I am a dog in court. Cold-blooded animal with the litigation. I'm no different than the next person. You can do the same thing. So they filed suit against Capital One Auto Finance, a division of Capital One Bank, alleging claims for breach of contract, unjust enrichment, securities fraud, and declaratory judgment. Already, I see, here's the thing. Ladies and gentlemen, it's not so much about the claims that you raise more than it has to do with the elements and the burden of proof that you have to do to substantiate these claims. Now, here's the first thing. When they want to talk about securities fraud, that is a very high bar. That is an extremely high bar that the courts put on you as soon as you use the word fraud. Now, fraud has their own legal elements. Fraud has their own legal elements. So when you're using the word fraud, you gotta understand the who, what, when, where, how. And you have to understand that anytime you use the word fraud, your complaint is being subject to Rule 9B. This is the particularity standard. This is the standard that will get your case thrown out if you don't ace it. This is the case that will get your whole, even if you aced, let's say, all the rest of your claims. Even if you ace all the rest of your claims, why do you think they call these special pleading matters? Pleading special matters. Now, let's go right here. Rule 9B. This is what they use to scalp pro se litigants to the white meat. This is what they use to get your case dismissed. Because when you allege fraud and you don't satisfy the heightened pleading standards under Rule 9B, you are going to get your case dismissed. What I'm trying to tell you is, in alleging fraud or mistake, a party must state with particularity. There. Now, particularity, this is what I mean about lining court rules up with case law. Particularity has their own meaning. Rules and procedures are normally going to be written in its broadest term possible unless otherwise stated. So a party must state with particularity the circumstances constituting fraud or mistake, malice, intent, knowledge, and other conditions of a person's mind may be alleged generally. Right? So, once again, if you're going to raise the word fraud, who, what was the fraud, when, where, and how did you suffer injury for that fraud? The problem that we're going to have, and especially in the pro se spaces, is that the fraud that we think it is, it's only fraud allegations that people are peddling online. You're not going to find the connection between what's alleged fraud, as what you may hear online, versus what are the legal elements to prove fraud. Even if you have all like the evidence smack dab in your face, you may think it's fraud. There's still a legal element to it. So it has to be fraud under the legal elements. And then once you satisfy the legal elements, your actual facts will be used to support it. But you can't just say fraud and be like, I uncovered the fraud. No, you can't do that. In declaratory judgment, Capital One moved to dismiss the complaint. Anytime you file a lawsuit and their initial response is a motion to dismiss, it is evidence that they believe that you haven't stated the claim. So instead of them now responding to your claims, they're basically going to use Rule 12b-6 as a way to say, Your Honor, since they haven't stated a cognizable claim in which the courts can even grant relief, you don't even have subject matter jurisdiction to entertain their claims. And since you lack subject matter jurisdiction to entertain their claims, then you can't even award them the relief that they requested. And since you can't reward them the relief that they requested, then this case must be dismissed. That is what a Rule 12b-6 motion really is. It's really an attack on the judge's subject matter jurisdiction to grant you the relief that's requested, because that's how court works. Whatever relief that you're requesting, if the courts can't even grant you the relief that you're requested, then as a matter of law, you have not stated a claim. And if you have not stated a claim upon which relief can be granted, I think that term I think it gets overlooked too much. Stating a claim upon which relief can be granted. Many people interpret that to mean the relief you can give me is right here in the pleadings. The relief that you can give me is right what I want. But the relief that the court can grant, they have to be authorized to do so. There has to be something in the statutes, the rules, the regulations that grants the court's authority to grant the relief that's requested. Sorry. And if that's not well pleaded in your pleadings, you're going to run into the same thing right here. Capital One moved to dismiss the complaint. The trial court granted the motion and dismissed Hopson's suit with prejudice. Now, why did they dismiss the case with prejudice rather than without prejudice? That is a big, getting a case dismissed with prejudice is a major issue. It's a major thing. Can never bring it back up. But she was pro se, and she got her case dismissed with prejudice. And we're going to explore that in today. So we're going to finish reading this case, and then we're going to get to the report. In this instant appeal, Hopson, still proceeding pro se, alleges in part that the trial court erred in dismissing her complaint. and for failing to liberally construe her pro se pleadings as required under Georgia law. For the reasons that follow, we now affirm. On appeal, we review the trial court's grant of a motion to dismiss de novo. A motion to dismiss for failure to state a claim upon which relief can be granted should not be sustained unless 1, the allegations of the complaint disclose with certainty that the claimant would not be entitled to relief under any state of provable facts asserted in support thereof. Meaning, everything that you thrown out there to say that I'm entitled to relief, none of it adds up. None of it lies up. And this is exactly what I mean. This is exactly what I mean about this space. The claims, allegations, and assertions, they're only good online for panel conversations. Leave it online. But when you go into court, just don't cite anything that you talk about online. Don't even talk about it. Have a whole new strategy. And 2, the movement establishes that the claimant could not possibly introduce evidence within the framework of the complaint sufficient to warrant a grant of the relief sought. Produce evidence, sufficient evidence within the complaint. This is when we move the envelope past theory to factual allegations, supported by anything on the record, anything that's observable will be admissible. Things of that nature. And declining a motion to dismiss, all pleadings are to be construed most favorably to the party who filed them. And all doubts regarding such pleadings must be resolved in the filing party's favor. So that is them continuing to give you the benefit of the doubt. You know, basically that's the court saying we're not really going to split hairs. If they said enough, as long as they, we get pro se litigants don't really know how to word things, don't really know how to put in the legal technical form. We're not really going to penalize them on formalities and pleading styles. But as long as we get what they're trying to say, and we'll construe it in the way that, like they said it in the legal term. That's pretty much all the help you get when it comes to construing pro se litigants drafts. Pretty much all the help you get. See Mayorga versus Benton. Now, first footnote, Hopson's notice of non-filing of Capital One's appellate brief and motion to substitute for decision on appellate's brief is denied as moot. That's dealing with, something else, whatever. So let's get back to it. All right, prime favor. Okay, so viewed in June 2022, Hopson entered into a retail installment sales contract for the purchase of a 2017 Toyota RAV4 for $32,975.46. The mere fact that $32,975.46 was typed on the contract, that is my evidence right there right at the door. They did that to me right after removal, so I brought up the fact that if relief can't be granted in federal, what's up with the PU? Yeah. That's the normal one thing right there. It's a known tactic. It's a known tactic, and bro, you already know about it now. Spoke about it now, but that basically, like, let's say they rule and they keep it in federal court and get you to respond. See, now all we do, or whatever they dismiss, give you 14 days, whatever amended complaint. The second amended complaint is going to look drastically different from the first amended complaint. You get what I'm saying? And that's going to get you through the next door, through the stages. That's one thing I know definitely well about federal courts. To get to the next stages, so they're not going to look at the second amended complaint as something as an extension of the first. The way it's going to be drafted and crafted is going to look like its own independent, like you're raising it all new again for the first time. So that is the benefit pro se litigants get as well. They get multiple bites at the apple, except for in this case. She didn't get multiple bites at the apple for the reasons stated below. Now, first thing right there, enter into a retail installment contract. Any contract, mortgage note, retail installment contract, credit card agreement. One thing that you have to look at, the contract makes the law. Whatever process, method, mode, whatever you're going to do, before you send it in, tender payment, tender performance, the first question that you got to ask yourself, the first question that the courts is going to look at, the first question that the opposing attorneys is going to see from 5,000 miles away is they're going to look at the terms of the contract. Whatever this person now is trying to tender, was it authorized under the contract? And whatever, if the answer is yes, then your debts will be discharged in your alternative methods of payment. If the answer is no, they're going to tell you this did not discharge your payments under the contract. You cannot unilaterally change the terms of an express binding written contract just because you found some new information later on down the line. Because if they would have did it to you, you would have 2 cows and a baby. Let them go change the terms of your contract and say, oh, yeah, the APR said 18%, but yeah, you're going to pay 30 now. You be like, hold on. It's not what we agreed to. It's not on the contract. See, equity goes both ways. Equity goes both ways. You can't always just want equity on your side, and you don't even want to give it. Goes both ways. The transaction was financed and the loan was assigned to Capital One. Under the terms of, I already see see an issue right there. Under the terms of the contract, right here. Why do you think the judge, see, they're telling you, the judge says right here, under the terms of the contract, you get, that's an underlining. Those are people that really know, they know what that means. The judge is viewing everything from the foundation of the contract. Her job, and it's a very extremely difficult thing to do, but it's not impossible, is to invalidate the contract from the beginning. That is a very, that escapes this space. How to legally invalidate the contract from the jump. Legally. To say, hey, everything on this contract is invalid. And here's why. There's no online theory that you can use for that. There's nothing online that I've heard anybody ever say that would be sufficient in that manner. Because the only way you can actually literally invalidate bringing the complaint first. A contract being invalidated that is not a merits-based complaint, the only thing that's going to happen is the case may get dismissed without prejudice and the underlying debt is still not going to be satisfied. And you just got to hope that there's extreme clouds on the title. You got to hope the statute of limitations. You got to sit back and hope they make a mistake. See, I don't believe in that reactive position. I believe bringing the full force of the law right to their doorstep, blocking off all escape routes. You can't do that 100% of the time if you always find yourself trying to defend. Now, even though, at least shout out to her that she brought the lawsuit, but once again, as we're going to continue to read, she made errors that you guys are going to point out these errors too, because these are the same errors that you continue to hear online every day. Under the terms of the contract, Hopson was required to make monthly payments to Capital One under the terms of the contract. Now, when we get to this semantics game on what's payment, every court in America is going to look at how does society view payment. How does a normal, everyday, reasonable person review payment? Prime example. Here's an exercise. This is how you do it. If you had an option and someone was giving you $2,000, they was either giving you $2,000 in Cash App, Apple Pay, PayPal, wire transfer, or cash, Federal Reserve notes, right? Or they said, take my bonded promissory note or my international promissory note or my self-created bill of exchange. The international promissory note, the bonded promissory note, and the bill of exchange were all typed up and printed out. Are you going to accept that as the $2,000, dollar payment? And if you will, just for the purpose of this conversation, then why don't you accept those instruments when you're selling your packages? Why do you request payment in Federal Reserve notes in order to give someone an international promissory note in exchange? Why aren't you accepting the same mode of payment that you are telling other people that they could pay their bills with? Why don't you accept that? Hey, you could pay your bills in the international promissory note. Why don't you accept that as payment? Always look at what they're accepting as payment. If what they're accepting as payment is drastically different from what they're advocating for, that is a red flag. Hopson later attempted to rescind the loan by sending a bill of exchange to Capital One in March 2025, claiming to revoke Capital One's security interest. Mensa, see, I'm gonna start pointing out the guru's names, which she's saying, look, that's Mensa, security interest, and invoke Capital One to pay the entire financial obligation of the contract. Hell, put them all in the pot. Hopson also directed Capital One to return all prior payments
You're rocking with the best.
Yo. Ah, there we go. God damn it. My bad, y'all. All right, let's get back to it. My bad. YouTube was frozen like a motherfucker. All right, let's get to it. Here we go. 1. Hopson alleged that the trial court erred in dismissing her claims despite her tendering a lawful. Stop right there. Remember I told you that semantics games that they play with lawful and legal? They want to play split hairs with ordinary meanings in the terms of words, wasting time, not really getting to the substance, playing semantics all day, asking stupid questions like, well, what's the definition of payment? Define payment. Well, I was just breathing today. Define breathing. And you know, I walked to the store today. Define walk. And you know, I got in my vehicle and drove. You mean conveyance? You mean your personal and private conveyance? No, I mean my truck, my vehicle. No, see, it's not a truck. Well, it goes over the weight limit to clarify for you. No, it's not a truck. It's your private conveyance. Well, I put the gear shift in drive today. No, you mean you was traveling today. Well, the letter on the says D. I don't see the T. It says D for drive. Well, you was traveling. No, I accelerated the gas pedal. No, you was traveling on the road. Well, you know, the law says that you can't go no more than 30 miles an hour. Yeah, that's only if you're in a commercial capacity. Like, get the fuck out of here. Stop it. Just stop. You ain't never win. You never get your traffic tickets thrown out on these arguments. You never win. Hopson alleged that the trial court erred in dismissing her claims despite her tendering, quote, a lawful bill of exchange as tender of payment, end quote. Did the contract allow for you to submit a self-created bill of exchange? I mean, let's just take the gloves off. None of your instruments are written on real accounts that you have direct access to. None of them. None of those self-created negotiable instruments has any real money or account backing it. The mere fact that you are citing statutes to support your fake fictitious negotiable instruments is evidence that you think Congress contemplated when, you know, making laws in the state, making these negotiable instrument statutes, that they were encompassing fraudulent negotiable instruments and legal valid negotiable instruments. Do you think the state legislators and Congress ever contemplated that you can use legitimate negotiable instrument statutes to support your fraudulent instruments? You ain't no fictitious alterations, fraudulent alterations. You do realize when you get a $1 money order, it has a serial number attached to it, that it goes back in the systems and knows that you gave them $1 cash. So just because you cross out the $1 and put $20,000 on it, you still have a $1 money order. You're just $24,999 away. And that little fake loophole, well, if there's a discrepancy between the written amount and the printed amount, the written amount controls. Yeah, that's predicated on you actually having a real discrepancy, not that you just wrote it all. See, the literal and literal mean, they take everything literal. There's no foresight. There's no insight. There's no interpretation. It's just a literal meaning. In her complaint, Hopson alleged that Capital One breached the terms of the contract. Breached the terms of the contract by failing to accept lawful tender, failing to acknowledge the discharge or offset of debt, and continue to demand payments from Hopson. Her contention is without merit. A bill of exchange is not a legal document or legal tender. CEG Hassad L versus Aldrich Pike LLP. 11th Circuit, 2020, November 24th, 2021. Holding that a bill of exchange, quite plainly, is not real money.
not real money. Although it appears that we have not directly addressed this issue, Thomas versus Surbank, and there's your ain't me, provides a helpful example. In that case, the plaintiff sent several letters asking the chief financial officer of a bank to apply the principal's balance to the principal's account for set-off. The same thing she just did. In another case in Alabama, December 7th, 2023, another person said the same thing she's saying here. You want to know where these people are getting this stuff from? You're on the app. You're on the app. That's where they get it from. You're right on the app where they get it from. And sent 2 letters of default judgment to the bank when the CFO did not apply the balance for set-off as the plaintiff instructed. Tell me every day it's always if they don't do it, you're in default. You don't do it, it is. If you don't do it, opportunity to occur. This is the response they not showing you. The response from the banks when they send that garbage in. They know they're getting the response. This is not a valid form of payment. This is not legal payment. Your account remains due under the contract. They're never going to post it. And granting the bank's motion to dismiss, the district court concluded the plaintiff's complaint was devoid of facts, plausibly suggesting any entitlement to relief. But hold on, Your Honor, this is what's circulating in the internet space. So it must be true because everybody says it's true online. Not in court. It's not true where it matters the most. This is why I say these arguments, they're only good for panel conversations and to give people who are severely behind on their debts hope. That's all it's good for. It's the hope that it will work. And granted the bank's motion to dismiss, the district court concluded, oh yeah, we already did that. Specifically, the court noted that plaintiff's claims were rooted. This is not me. This is not me. I'm not saying it. Do not get mad at me. The court noted that plaintiff's claims were rooted in frivolous sovereign citizen theories and that the bills of exchange that the plaintiff issued as an attempt to pay his debt were not valid payment, but rather a worthless piece of paper. And this is why they can only show you those text email wins. Look, y'all, see this text right here? Got another card discharge. Look, y'all, you see this email above the screen? And the emails is always written in a conspicuous manner that it's always written in a way that a person that's legitimately happy would not be focusing on the things that's written in the message. It's always written like this. Hey, boy, you a fool. You did it. It worked. The bank said we don't have to make any more payments and that the debt was discharged. It's always the buzzwords that's going to be in the webinar or the packet. The debt was discharged. I remember when I was in your webinar last Wednesday, in which you got another one coming up Thursday that I heard you say, that you said that if we get it, it's going to get discharged. And that's exactly what happened. The bank said, just wait. They're going to call us back to walk us through the next steps. Thank you. We got this all from your webinar. I'm like, get the fuck out of here. Anybody that's really happy, they ain't worried about the webinar. Nah. It's going to be some old shit, bro. Hey, the bank just sent me this. Look. Put a trophy emoji sign. Look, the bank just sent me this. You don't never see the attachments. It's always a text email win. You don't never see the attachment. Nah, you don't never see the attachment. Nah. The fuck out of here. See Harp versus Police and Fire Fair Credit Union. Dismissing with prejudice breach of contract claim where it was clear from the complaint's exhibits that the plaintiff's bill of exchange was not valid legal tender for payment of credit card debt, and rather than a legally enforceable document noting an existing debt that defendant owed to her, plaintiff simply wrote an array of financial buzzwords on her credit card statement and tried to pass this off to defendant as valid legal tender for her credit card debt, aka the coupon method. Mm-hmm. 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 I know. I know. I know. I know you win. I know all your debts are discharged. I know it. I know they are. Yeah, of course they are. Uh-huh. Of course we know. Yeah. Yeah, they're all getting discharged. Every single 50 people get the document, 50 people go and get their time. Yeah, they are. Right. In short, Hopson has not identified any specific contractual provision that was breached, and to the extent that she argues that repeatedly sending instructions to apply principal's balance to principal's accounts to offset the entirety of the debt obligation amounted to legitimate performance under the contract. So how was sending instructions to apply principal's balance to principal's accounts tender of performance? Because I can't perform unless you perform. So that's my tender, the performance, by asking you to perform before we perform on the stage together. Then we got to get the performance together, then get the choreograph for the performance and get the lighting. Shut the hell up. It's all a scheme. I don't care. They cite Bible verses, spiritual law, God's law. They promise you a new kidney. I don't give a damn. It's all an attempt to extract money out of desperate people and desperate situations. That's all it is. That's all it is. Now, one thing that's worth noting is that the court said she has not identified any specific contractual provision that was breached. That's very important here because, as I stated earlier, what did the contract say that allowed you to tender this stuff in? What a part of any legal, valid auto mortgage credit card contract that's going to authorize you to pay in a manner that's not already stipulated and enforced and memorialized through your signature? Any process, any alternative methods of payments that they want to tell you to do, look at your contract and see if it's authorized first. Because if it's not authorized under your contract, you are sending in a worthless piece of paper. And that right there, if you look at your contract, before you send the money, and you don't see nowhere where it says that under this contract, you can do this, then you would save money. But if you sent the money first, and then you want to go back and look at the contract and see if it lines up, if you're allowed to send that instrument in, you've wasted your money. Now, to offset the entirety of the debt obligation amounted to legitimate performance under the contract. Her assertion is completely devoid of merit. The trial court therefore properly dismissed Hopson's claim for breach of contract for failure to state a claim. In a related claim of error, Hopson asserts that the trial court erred in dismissing her unjust enrichment claim, despite allegations that Capital One retained benefits without lawful basis. How many times have you heard the term unjust enrichment online? How many times you heard that being misinterpreted? I could count about 150 from the teachers down to the students. In her complaint, Hopson alleged that Capital One was unjustly enriched because it continued to demand and retain loan payments from Hopson even after her lawful tender of payment. As previously discussed in Division 1, Hopson's bill of exchange and letters to Capital One did not constitute legal documents or legal tender. Let's stop right there for a second. So you mean to tell me these documents that y'all putting together, it's not a legal document? Second, an unjust enrichment theory does not lie where there is an express contract. There you have it. There you have it. You have an express written contract. There's no unjust enrichment. See Cox versus Athens Regional Medical Center. In her complaint, Hopson specifically alleged that she entered into a valid and binding contract for the financing of a motor vehicle. Guess what, Ms. Hopson? You didn't even have to admit it. It's already going to be looked at like that, and that's exactly what it is. Because a valid contract existed between Hopson and Capital One, the trial court did not err in dismissing Hopson's unjust enrichment claim. You notice how they're taking all her claims and going straight to the letter of the law, going straight to it. So when I say your claims, oh my God, who gives a shit what they tell you online? It got the four-part standard. Just a four-part standard. The rule, the regulation, the statute of authority, bam. Got to have that identified. And then you have to have the case law, case citations, in which the interpretation in those cases has interpreted the rules, regulation, and the law, all that, right? Right? And then your specific facts of the case. No, I'm sorry. That's the second one. Rules, law, court, standards, all that first. Second, the facts of your case. Your specific facts of the case. Third, case law to support the facts of your case. Because the case law you're supporting, the facts and elements either line up with yours or you're citing them to make a distinction. Or if the judge denied this, you can cite that to make the distinction, to narrow your claims. That's the third. Now, the fourth is to ask the court to apply the reasoning in the case that's favorable to you and take that reasoning and apply it here. Nah, you just get a theory and just go run right to the courts with it. Because contrary to popular belief, many people think that as long as you hear it online, that it must be true. As long as this person has enough followers, then it must be true. As long as they're popular and they have a group, everything they say is gold. But I'm gonna be honest with you. A lot of y'all favorite gurus be making a lot of errors. I'll just say that. Leave that alone. What's the problem? The client always pays for the guru's mistakes. The client always pays for the guru's mistakes. If the guru is saying something that they don't have true understanding and knowledge in, the client pays for it. If the guru misinterprets a case law, the client pays for it. The guru don't pay for it. The client pays for it. So knowing that, taking on and assisting people with their cases, you have to be extra, ultra careful. But here's the thing. If you got gurus that has no problem with filing lawsuits and complaints for others or assisting them, but they don't have no public records of them filing their own lawsuits, them having consistency of being through this, them going through their own trial error, them going through the fire themselves, I find that to be very interesting. I'd rather take an attorney or a person that has a 50-3 record than a person that just got a 3-0 record. that has tried 53 cases, 150 of them, lost 3, I'll take that person over I'd take a person that's just 3-0 in 3 little petty credit card cases. I take, you want to know why? The intangibles are with that 53 case person. The intangibles are there. The ones that you'll be their 4th case in, they ain't got enough experience. The 53 person, the intangibles are there. The experience is there. Now, Hopson's, see the ID. Hopson's unjust enrichment claim. A claim of unjust enrichment claim because of existence of a valid contract between the parties. 3, Hopson next contends that the trial court erred in dismissing her securities fraud claim under OCGA 10-551 because Capital One omitted material facts regarding ownership and lien holder status. Again, we find no error. Once again, securitization, that's another cliche word now. There can be up as many 15 players in a securitization transaction. 15. 4 is of which important. It's 3 major transactions that are going down before you get to yours. You don't understand your contract, your transaction in full until you understand the first 3 that took place before you walked in the situation. And that is one of the pillars of Set You.
Don't miss out on this opportunity to litigate like a seasoned professional. Join the Supreme Elite Team University.
Thomas in the lobby. Folded thicker than a skyline. Credit acceptance on a resume with stories in the fine lines.
Securities fraud. They don't even understand what a class action lawsuit looks like. They have no clue about class action. And I guarantee you, this securities fraud claim is a misinterpretation of OCGA 10-1-51. And here we go. In the first instance, OCGA 10-551 covers fraudulent acts by investment advisors. Specifically, the statute prohibits a person that advises others for compensation, either directly or indirectly through publications or writings as to the value of securities or the advisability of investing in, purchasing, or selling securities, or that for compensation and as part of a regular business issues or promulgates analysis or reports related to securities from engaging in fraudulent contract. Once again, no connection to her case. And you want to know, when pro se litigants makes claims like this that just has no bearing in connection, they start to think AI did it. They start to think AI did it. Because one thing about AI, yes, it's prone for mistakes. It still takes human eyes, human understanding. It still takes, they could cite a case all they want. The case that's cited is not always going to be the accurate case that applies. I'm telling you, pro se, and that's the basis of this live, pro se litigants are getting the false sense of confidence because they have access to AI. Sorry. These law firms, the courts systems, they don't use ChatGPT. That is an open platform. There are certain things that I don't give a damn if you speak into it. There's just certain parameters that it won't get into. Why do you think these lawyers and these law firms and these securities firms, they got custom models built? It's customized. It's built from the ground up. Hundreds of hours of stress tests. They get these things built. You know how much money they spend on AI infrastructure? Yeah, they spend millions of dollars on it. The complaint alleges no facts showing that Capital One qualifies as an investment advisor. In fact, OCGA 10-5-2-7 subsection 17F specifically excludes banks from the definition of an investment advisor. Capital One Finance is a division of Capital One Bank. In any event, Hopson failed to point out any valid legal authority to support her claim that a lender must disclose securitization or that securitization is unlawful. Right there. This is the difference between online assertions and legal and valid authority to support it. There's always going to be a disconnect. Out of 100% of online assertions and claims that you've heard over the last 5 years, less than 0.000000001% will ever have any valid legal authority to support it. Remember, this is the legal lens. C. Milner versus New American Funded LLC. Numerous courts over the last several years have squarely rejected the patently frivolous notation that securitization or non-disclosure of securitizations constitutes material credit terms or gives the borrower any recourse to avoid paying her mortgage. Once again, what have I always said? The courts just said it here. The debt elimination mindset. If they did not connect securitization to I don't owe anymore, to I don't have to pay you, to oh, the debt is over, they wouldn't be raising securitization in the first place. There's no argument in mass that's raised online that is not connected to a debt elimination. Even accepting as true Hopson's allegation that the loan was securitized, Hopson has failed to show how any such securitization would have any impact on her rights and obligations under the contract. I told you, the securitization is going to auto contract is going to take on many new formations as it flows through the secondary market. It's going to take on many different names. It's going to be governed by many different rules, many different accounting standards. There's going to be at least 7 different standards that are all interconnected. And you got to tie all 7 back together. They're all interconnected. And they're just governing authorities. They're basically, it's not statutory law. It's just guidance, authoritative guidance. You think that you could just cite one accounting standard? Go ahead, because they all cite the same ones. It's about 6 or 7 more that has to be tied into it. And each section has its own rules on how it's governed, how it goes. And another thing, securitization does not stop the obligation under the contract. This is why when they go to court, they freeze the contract right at the closing stage. Now, I know that as soon as they do what they do, create the account, I know all the projections. I know all this. I know the assumptions they use. I know all that shit that goes on behind the scenes. I know all that materially affects the remaining balance. I know that whatever presented on a financial statements of position as it goes back to your obligation, I know if I take that number and go back to your original contract, that number that's on their financial statements of position is going to be significantly less than the amounts that they're trying to claim in court. Why do you think the ledger is working? Why do you think they can't explain the numbers? Why you think they can't track the source? See, over here, we don't need to ask them to produce it. We don't need to ask them. We already know the answer. We don't ask them to produce. We ask them to explain. Explain 20,000. This is unaccounted for. This is hanging. Yeah, you slid it up in the advances. You slid it in there. We done took every penny and dissected it. 20,000 is unaccounted for. Explain this 20,000. See how we just pinpointed that? Explain making identical $77 charged on one late fee, $77 for the period. Explain 4 different charges for the same late fee period of May 13, 2023, and almost 16 months after it. Explain those 9 cent. What's the why do you got 4 just 9 cent? What you doing? You testing something? Explain these 4 charges of $77 that's way outside the late fee period, as the note says. Can you explain this $20,000? This $20,000, what charges under the contract? Remember, sign the contract. Remember, it's a binding agreement. Yeah, it's binding on you just like it's binding on us. It's binding on you too. Remember, equity goes both ways. So explain how you came up with these charges, because it's nowhere stated here. Or maybe it's that the charges are not really authorized under the contract. It's authorized under your private agreements. You're just trying to ditch it back over here. See, I know it's there. I've actually read them. Since I know it's there, I don't need to tell you the source of it. I know the source. I just need you to explain the source. Go ahead. I need you to explain how you get one set of judgment figures. You update the judgment figures. Now you got a new set of judgment figures. That's $4,732 difference. Now explain the difference right there. How you explain this difference? This is still unaccounted for. How did it jump up from $4,732? So you haven't even reconciled the first judgment figures. Now you're trying to bring a new one. Now, if you come with a third one, you haven't reconciled the first and the second. So all I'm going to do is just take the difference between that and add it to the 4,000. Now explain this 10,000. They ain't adding up. See, accounting is a very tricky thing. Accounting is very intricate. One number, 1 cent, 1 penny's off, the whole balance sheet's off. It's that intricate. So if you got one set of numbers that don't add up, you can't pack a second set of numbers and think that all the numbers are going to reconcile. And the more you add new numbers, the more it's going to be a domino effect. Come on, Loan Depot. September 1st. It's around the corner. It's what day is it? Today's August 20th. You got about 12 days. You ain't update them judgment figures yet. You want to go back with those same numbers? You 12 days away. Come on. Oh, that RESPA notice of error, the clock is tolling too. I think you're already late. I'll go back and check. I think you're already late. But let me tell you this. If you respond in that RESPA notice of error, you better watch how you respond. Because anything that you respond to is going to be my evidence. However you respond is going to be my evidence. It don't matter what you say. It's my evidence. Want to know why? Want to know why it's my evidence? Because statutory, under the statutory, you only have 4 ways of responding. You only have 4 ways of responding. You can either say, we find no error. Oh my gosh, there's already error in court. We can say, we decline to talk because you're in court. Uh-oh, not sufficient, statutory. We can say, oh, we made a mistake. You're right. Here's the new figures. Ooh, now you're just compounding. See what I'm saying? See what I'm saying? This is called, hold on, let me go to the figures. The hidden figures pattern is found. 4 stated balances exist for the same loan. Between them, the debt climbs at increasing speed. April 16, 2025 through September 30th, 2025, $199,692.12 jumped to $208,392.97. Over a 160-day period, it increased by $8,700.85. That is $52.10 per diem. Annualized, if you go annually, that is $19,016.83. Now, if you go to September 30th, 2025 to March 27th, 2026, the balance, 208,392.97 jumps to 219,561.44. 178 days, it increased $11,168.47. That's $62.74 per diem. Annualized, that is $22,901.64. Now, March 27th to this year to August 21st, which is tomorrow, it's at 219,561.44. Now, by August 21st, it's going to be $240,393.88. Over a 147-day period. That's a $20,832.44 increase. That is $141.72 per diem, which annualized, that's $51,726.81. And all of this shit is after the commencement of the lawsuit. Stop playing with me. I am a numbers guy. You don't think I know how to legally cook the books? You think I'm gonna let y'all cook my clients' books? When I do the same shit? I mean, all of them do it up there. You think I'm gonna let you do it? Now, you can do it on somebody else. Contract interest on the modified unpaid principal balance of $193,089.28 at 3.125% interest. That is $16.53 per day. They're just sliding in there per day. It's the ledger. It's how we break it down. And here's the thing. There's no template I give you. There's no template for this. There's no template. This is a custom thing. This is built on everything that they gave to you, meaning the evidence is their records. The evidence is their filings. We don't need it. Be honest with you. I don't need discovery. For real. This is the discovery right here. We don't need a forensic audit. A forensic audit ain't going to produce this. Forensic audit ain't going to produce this. No mortgage forensic. They ain't going to produce this. There ain't no ebook for this. There ain't no ebook for this. This is the 5 lenses of the contract. That's what this is. This is the Supreme Elite Team University. This is a product of the Supreme Elite Team University. See, this is what my group members, this is what they're going to be prolific at once the university this semester, when this school year ends. This is what they're going to be good. And half of them are already there now. So I was telling Darren last night, Darren, you already know what to do. You already know what's going on. You already know what to do. It ain't just here, there you go, I'm done with it, got the money. No, anything, my product, anything I put up is a representation on me. So I take it just as serious for the next person like it was mine. I treat it like it was mine. You think I let credit acceptance play with me? That was the beginning of the hidden figures. That was the beginning of it right there. Went down and broke every penny down. But here's the thing that makes it so special. It's only tailored for one person's specific situation. It's only tailored for one person's situation. Like I said, there's no template to pass it off as. The template is the understanding. The template is the hours and years. The template is the 36 months deep dive. The template is reading professional documents, professional accounting books, the stuff that the professionals read. That's the template. The template is the understanding. The earliest observed accrual rate is roughly 3.2 times that. The most recent is 8.6. Over the full 492 days from April 16, 2025 to August 21st, 2026, the claim grew $40,701.76 on a note whose contract interest over that span is about $8,133. So the contractual interest amount on that span is only $8,133. But what did they file in court? Numbers that grew to $40,701.76. And yes, you're going to explain the difference from the contractual interest accrual rates to what you filed. Explain it. I'm not saying it's illegal. I'm not saying it's legit. No, explain it. Explain the numbers. Explain the hidden figures. Explain it. Y'all, we don't got to play, oh, this ain't right, this ain't right, this ain't right. Oh, no, it was the contractual interest rate on this time is $8,133. Hell, when they filed, it grew to $40,701. Can you explain the source of all these items? Is there, where's, you got any invoice for it? What explain how this calculate. This is nothing more than making them do work. Remember, the lawyers aren't the accountants. You know who can explain this? The ones who does their balance sheet. The ones who prepares their financial statements of position. Want to know who can understand this? The accounting firms that they hire. This is outside the scope of Jacqueline Biscuit, the attorney from ends.
I am intrigued.
Well, think about the millions of automated default notices, bills, and legal warnings sent out every...
This is what they can explain, the attorney. It's not the attorney's job to break down all numbers. And with the witness, they had Dennis Bush there and they had the other accountant there at 2 proceedings. What did they proceed to do? Read from a screen. What do we say? It's not good enough. Explain the difference. What did they do? Read from the screen. They called her back up to testify one more time. What did she do? Read from the screen. Was that sufficient enough for the judge? Hell no. And guess what? When you are in default and you at the stage where all they got to do is prove the figures. The reason why this is so powerful, because this is a statutory element now. The amounts due with certainty. This disrupts the certainty, which damages their burden of the amounts due. They was already in judicial default, already had 60-some filings by these gurus, notice of trespass, notice of interest, always, you didn't file the tax returns. Hey, well, let me see your service agreement. Hey, let me see your custodian agreement. Hey, let me see all your agreements. Hey, let me see this. Let me see that. Let me see this. Let me see this. I want to know this. I want to know this. What capacity are you suing in? Where are you suing in? Are you this? Are you that? Hey, fuck all that. Let's get straight to the numbers. That's the most important thing that they got to prove. We attacking that. Let's get to the numbers. Had a whole script for trial. Throw that shit. Hey, yo, throw that shit on the other. We stand right here. I found a soft spot. We're going to attack the numbers for the rest of the case. Rest of the hearing. Attack the numbers. Ask this. Ask that. Hold on. What number they just say? Challenge it. I got a different number. These numbers ain't adding up. The court reporter. I got a different number. Uh-oh. I got a different number. Uh-oh. We got conflict. Let's go. We gonna ride right here. We ain't going nowhere else. Throw that damn script to the side. We gonna play the rest of this hearing by ear. Stated another way, the $240,393.88 claims exceeds the January 2022 modified principal by $47,304.66. interest from April 1st, 2024 through August 21st accounts for roughly 14,416 of that. The remaining 32,900 is escrow, advances, fees, and costs. My bad, y'all. I made a mistake. I thought this was the Loan Depot case. My bad. This is the Georgia case. Damn. My bad. I thought I had the hidden figures for the loan. Nah, this is the Georgia case. A totally different mortgage case. My bad. What I've been reading, this the Georgia case. This the Georgia case. See the ledger? I thought I was reading for the Loan Depot one. I said, hold on, Brett. I know that's Georgia. But even look here. Doesn't matter what contract it is, what mortgage, it doesn't matter. I know when they give you the when they give y'all the what they call it, the you know when you respond to the QWRs and they see the letters, they see those little servicing statements, and they see the whole little printout customer activity sheet. Yeah. Every penny is being dissected. We are commencing audit. We are conducting an audit on them. 100% audit. Now let me see. We're gonna get back. We're gonna get back to that for a second. Oh yeah. There's a few people that's gotten the ledger from most recently. Yeah. You got it. I think, I don't know if he in here. Yeah. He is in here. Which one we gonna pull up? Yeah, let's pull this one. The hidden figures. And the reason why the hidden figures is so the reason why I say it's so important is because there's nothing here that's a theory. You know what I'm saying? There's nothing here that's a theory. Everything here is based on their own assumptions. Now let me get this pulled up. It's based on their own assumption. It's on their own records. It's what they filed into the case. And there's nothing here that is theory based. That's you know, none of that. Now let me put it on the big screen for y'all. Everything is 100% what they filed. So you can't you can't get mad at us. You can't get mad at us. Can't get mad at us. This is what you filed. This is your claim. You get what I'm saying? This is your claim. These are your claims. Like, we're not playing. We are not playing. We are not playing. Let me pull it up here. The ledger. Let me pull it up. We ain't playing. The ledger. Hey, listen. I don't make the rules. I do not make the rules. I follow protocol. I don't make the rules. I follow protocol, ladies and gentlemen. I don't make the rules at all. All right, for some reason, it's not pulling up. So let's go back here for a second. I'm going to pull it up in a second. And accepting it even as true, Hopson's loan that was securitized, Hopson failed to show how any such securitization would impact her rights and obligations under the contract. The trial court thus did not err in dismissing Hopson's claims for securities fraud. Hopson alleges that the trial court erred in ignoring her redress contract and allowing Capital One to enforce the terms of the original sales contract. Although difficult to follow, the quote redress contract that Hopson appears to reference is the original contract that she attached to the bill of exchange and sent to Capital One in March 2025. One which she wrote, I revoke, on several pages and marked with a stamp that reads, for presentation to the United States Treasury for conversion into the book entry securities. Once again, I just made a video on that. I made a video on that. You know, I made a video on that. It's the 31 CFR 328. Tamika was doing it. This person doing, all of them doing it. That's a misinterpretation. That is a misinterpretation. Watch this. I made a whole video on it. I made a whole full-fledged video on it. I mean, not a full video, a short. Watch this. Wow. Yeah, I don't care what you're seeing. It's all good, bro. It's all good what you're seeing. Whatever you're seeing, you right. You're supposed to be seeing. No worries, bro. No worries of what you're seeing. Go ahead and see what you need to see. Let me tell you exactly. I made a video on it. I made a video on it. I'm telling you, it's going to be 98% is going to be a misinterpretation of what you think you read. Let me see. Let me pull it up. Yeah, securities fraud. Ladies and gentlemen, I know we want to think it's that easy. Here we go, right here.
Under 31 CFR 328.5 through 328.6.
I guarantee you it's a misinterpretation. I guarantee.
Most people don't realize that under 31 CFR 328.5 through 328.6.
I guarantee you it's a misinterpretation. Now, right here in this case, this is what she's talking about right here. I revoke on several pages and mark with stamps that read, for presentation to the United States Treasury for conversion into book entry securities. That is exactly what this video is talking about. She's doing that. She didn't say it. She didn't go by the name, but her lawsuit is nothing more than a mixture of online theories. That's all her lawsuit is.
328.5 through 328.6.
I guarantee you it's a misinterpretation. I guarantee you. Forms of endorsement. I told you. You know what this relates to? Treasury securities. Securities that the Treasury actually issue through the Bureau of Fiscal Service or a bank. Meaning a Treasury note, a Treasury bond. So this endorsement, it's not dealing with your coupons of bills. It deals with the actual Treasury security that you purchased through your Treasury Direct account, which you established through your checking and savings account. Meaning you still need money to buy these securities. Told you. Told you. It's the same old. They was teaching that stuff. All of them was teaching it. Jonah Bay, Usabel, Tamika, Major, everybody, Treasury securities. They was telling people, go get the endorsement stamp. Stamp your securities. Send it to the Bureau of Fiscal Service. Well, do y'all want to know what the response that you're going to get when you try to send any of those forms on to the Bureau of Fiscal Service, that in any relation you're tying back to your social security number or some type of estate or some type of liquidating securities, like, you know, that Patrick Devine stuff back then? You want to know what happens? You actually want to hear a response that they never going to tell you, the response the Bureau of Fiscal Service is going to give you? Because they're the ones that are responsible for processing securities. They're one of the biggest paying agents of the U.S. Treasury. They're the ones that actually cuts the checks, mails the check. The IRS, like when you get a refund, like check in the mail when you was getting them, speaking legitimately, the IRS would send the file over to the Bureau of Fiscal Service. Once they're done, they send the file over. The Bureau of Fiscal Service cuts the check and it gets mailed out to you. That's why it comes in the Bureau of Fiscal Service name. The Bureau of Fiscal Service pays your government benefits. The Bureau of Fiscal Service pays, you know, all your government benefits and all that stuff. It comes from the Bureau of Fiscal Service. Social Security. Like you get a Social Security check. Like That's the Bureau of Fiscal Service. So they actually know what's a real security, what's not a real security. But give me 1 second. I'm going to pull the file up and I'm going to read to everyone the actual response that they're not going to tell you that you're going to receive when you send these fraudulent instruments or trying to liquidate any securities that you think is tied to your birth certificate, that you think is tied to your treasury securities, and the manner in which people want to go about doing it. Like there's a pot of gold at the end of the rainbow. 1 second. 1 second. Give me 1 second. And we going to give me 1 second and we're going to do it. 1 second.
They rolling the dice, we win cause we plan. The things that they teach don't know how to stand. I'm a wrist like a stage, they can't glance. You look like you wanna let go of stress. What's up? I thought so. Oh, I am the blueprint. If not, why you copy me, fam? What's up? I thought so. Okay, I cannot help that they copy. Hey, I am their dad, call me Poppy. Yo, they wish they created the set. Yes, they on my D like a jockey. When it comes to the print, I'm the blue. Who? Every complaint, draft is smooth. Supreme Elite team be the ones. Yo, I created my own school. Facts. I came from the trenches.
1 second.
Benches.
Load up.
With exhibits. My craft is exquisite. I find where they hiding them digits. The cancer is not in remission. Hey, please pay attention. You can't recreate the five lenses.
There you go. Right here. April 22nd, 2022. And this was sent to me because one of these online gurus, then this person was actually in the class. And she heard me speak about this. So she sent me a message and said, hey, is there any real way that we could liquidate our birth certificates, or is there any money for us at the Treasury based on it? I said, man, absolutely not, especially not in the ways that they think. Well, here's what I got. Look, dear blank, we receive your multiple special form requests for payment of securities, SF form 1522. However, we did not receive any bonds accompanying this form. Meaning, if you had the actual bond, the treasury security that you was going to redeem, that you actually purchased, that's supposed to be attached to the form telling them to liquidate it and payment. The serial numbers provided on the form are not valid United States saving bonds number, aka social security number, birth certificate number, aka. If you are suggesting that you are entitled to funds through your social security number or birth certificate, then you have been misinformed. Your birth certificate and social security card are not capital NOT securities, and therefore there are no government funds to which you are entitled because you possess these documents. This is a birthright / sovereign citizen scam, and continuing to pursue this in any way can lead to fraud charges. For more information on this type of fraud, please visit our website at www.treasurydirect.gov-institutions-state reg /fraud /birth certificate bonds.htm. We are unable to assist you concerning this matter and consider your request closed. No further action will be taken. If we receive further correspondence from you concerning these types of fraudulent securities, we will refer the matter to the Treasury Office of Inspector General. Sincerely, Treasury Services. I know, don't leave now. Don't leave now. Don't leave now. You know what hit dog will always holler? Those the people, the ones that just left, those the ones like, damn, I'm still waiting on mine to be processed. It's been 6 months. See, he killing my hope. Damn, I did spend money on that. Damn, I do believe that's true. Well, this is not me. This is the Treasury Bureau of Fiscal Service. So, is it really me that you're mad at? Would it really be me that you're mad at? Now, just let's be honest. Is it really me that you're mad at, or would you just, you're just projecting it on me? Is it me? Or are you really mad at yourself for believing in something that deep down inside you knew wasn't, or you're really mad at yourself? Or are you mad that whatever reality that you had in your mind that you was going to live off of this, it's been evaporated, it's over? Are you mad at the realities of life? I understand if you are. But what I just read still doesn't stop you from pursuing it. You have the choice and freedom to continue to pursue what you want to pursue. What you don't have a choice and can control the repercussions and the consequences that come from them. See, that's what you can't control. I think many people want to control that aspect as well. You play around with these people's system, you playing around with their securities, you're going to find out. F around and find out. You're messing around with their bread and butter. That's how they eat. When somebody mess around with how you eat, how you gonna react? It's no different. But you could continue to try. I'm not telling you what you can't do. Go try. Only thing I'm saying is, if you're taking advice and going to do something because you brought the process from somebody, all I'm saying is, the same way that you're going to praise their work and defend their work when you're on panels with people like me, the same way you'll defend a teacher. Just defend a teacher when the FBI and the Secret Service and all them come knocking. Defend the teacher. Don't be so quick to point the finger at the teacher, because that's what a lot of y'all do. Y'all defend them online. Then when the ABC boys come, y'all willing to turn them in. So if you know you're not going to turn them, you know you're not going to defend them when the government comes after you for based on what they did, then why would you defend them online against people like me? It's a fake, superficial defense. You know, if the government comes and wants to pursue charges against you and they say, hey, you going down for this unless you tell us who you got it from. Y'all know y'all not going to be like, man, shit, that's my teacher, I'm going to defend it. Nah, this is legit. Take me to the box. Y'all know y'all not going to do it. Y'all know y'all going to tell him, hey, I got it from him. I ain't know. You see what I'm saying? In the bottom right corner of some of the pages, there is another stamp that reads canceled. According to Hopson, she modified or rescinded the original contract via this redress contract. That's another social media process. However, it is elemental that it is not possible to have a unilateral modification of a contract previously entered into between the parties. Meaning, we always say this, just because you found out later on and you got this new way of living doesn't mean you can go back and undo what was already done. You can't just change the terms of a contract, just like they can't change the terms of a contract. You notice how you would act if you would just unilaterally change, if they would just change the terms of the contract without a written express consent by you as well, mutual agreement of the parties. You notice how you'll be upset that they did that. Now just take equity and reverse it. And that's the problem. Nobody wants to give equity as well to these people. Y'all want to take, demand, point out every little mistake, but you don't want to be accountable for when you make your own. I don't understand it. See American Express Travel Related Services versus Burrow. As a result, this claim is, once again, without merit. Hopson broadly asserts that the trial court erred in failing to liberally construe her pro se pleadings, thereby denying her the protections owed to self-represented litigants. That is a horrible argument. Here, as previously discussed in Divisions 1 through 4, the trial court properly dismissed Hopson's complaint for failure to state a claim for relief, and even liberally construing the pleadings, Hopson's claims were without merit, and dismissal of her complaint was wanted. Finally, Hopson argues that the trial court erred in dismissing her claims without allowing discovery, which foreclosed her ability to present evidence in support of her substantial claims and deprived her of due process. This is when you're punching at the air. That section provides that if a party files a motion to dismiss before filing an answer, and pursuant to the provisions of this code section, discovery shall be stayed until the ruling of the court on such motion. You see what I'm saying? That's simple rules of procedure. That's the procedure. So she made an argument in which the procedure says something different. And this is when they know that either pro se litigant, this is the thing courts deal with pro se litigants. You making arguments that the rules and laws already settled on. So it shows that you're not really putting the real work in. You may think you're putting real work in because you raising a bunch of arguments, but you're not putting the leg work in. And the reason why they're not putting the leg work in is because AI has caused so many people to think that they can skip a lot of steps that takes real leg work. And we're going to get into that. Capital One filed a motion to dismiss on July 28, 2025, which automatically stayed discovery. The trial court dismissed Hopson's complaint on August 22nd. The court, under section 911-12J1, the court shall decide to dismiss within 90 days following the conclusion of briefing on such motion. As a result, the trial court did not err by staying discovery upon the filing of the motion to dismiss. In any event, Hopson has, quote, not articulated any evidence which she hopes such discovery would uncover that will be relevant to, end quote, the issues here. See Hawkins versus Blair. As a result, this claim also fails. Accordingly, we affirm the trial court's dismissal of Hopson's complaint. Now, this is the part that really gets to the hallmark. This gets to the hallmark of what I wanted to talk about. As Capital One highlights, Hopson briefs were replete with inaccurate citations, which due to their nature appear to be fabricated by artificial intelligence. Capital One asserts that the use of these citations constitutes an abandonment of Hopson's claims. So let's say you had a claim and you state the claim, and then you go to ChatGPT or AI to find the case. They cite the case. You just copy and paste the case. You didn't read the case. You didn't catch if there's any distinctions between that case and the facts of your case. You didn't get the rulings. You didn't get the final order. You didn't see if that case is overruled. You didn't transpose that case with multiple different cases to see if there's a consistent in rulings. And you didn't see if the Supreme Court overturned it. You didn't do none of that with that case, right? They're saying that the mere fact that you cite and fabricated inaccurate case, that you technically abandon your whole argument based on that inaccurate citation. Capital One asserts that the use of these citations constitutes an abandonment of Hopson's claims. In this instance, we do not find that Hopson abandoned her claims. However, we take this opportunity. You want to know why they did that? Because it was like, it didn't even matter if she abandoned or not. She didn't even state a claim on any of them. And this is the result that Ms. Hopson got, that I know at first she didn't like it, but this response was really a call to her beliefs and ideologies and the things that she follows online. These rulings like this literally would tell you that everything you paid for, everything you researched, every rabbit hole you went down has been in vain. So in reality, you're still on first base. For a lot of people, that's a hard thing to accept. And I understand why. And however, we take this opportunity to remind Hopson that all litigants, even pro se ones, are responsible for verifying what they filed before this court. Her failure to do so has caused Capital One in this court to expend unnecessary efforts to discern her claims. See Matthew versus Prod Innovations Research LLC. Before this court, artificial intelligence is optional. Actual intelligence is mandatory. Hopson is cautious that the further use of fictitious legal citations may result in sanctions. See Court of Appeals Rules 7E2. The panel of the court rulings on a case, with or without motion, made by majority vote to impose a penalty not to exceed $10,000 against any party and or party's counsel in any civil case in which there is a direct appeal that is determined to be frivolous. So what are we saying with that? Let's get into the issue. ChatGPT, AI, and the pro se shortcut. The machine will write your brief in 90 seconds. It will not tell you that 4 of your 6 cases do not exist, and the court will not accept that as an excuse. As mentioned in Maddox versus Product Innovations Research, before this court, artificial intelligence is optional. Actual intelligence is mandatory. The ruling. So a Georgia appellate panel just named the problem out loud. On May 20, 2026, the Court of Appeals of Georgia handed down Hopson versus Capital One Auto Finance, Division of Capital One NA. On its face, it is an ordinary affirmance of a dismissal under OCGA 9-11-12-B6. Read past the disposition, and it is something else entirely. One of the clearest judicial statements yet about what happens when a self-represented litigant gets a chat box. When a self-represented litigant lets a chat box build the argument. Taffeta Hopson sued Capital One pro se in June 2025 over an auto loan. Her theories will be familiar to anyone who spends time in the consumer defense corners of the internet. That a bill of exchange discharged the debt, that the securitization of her loan was an undisclosed securities transaction, that the contract could be unilaterally modified or rescinded. She pleaded breach of contract, unjust enrichment, securities frauds under OCGA 10-551, declaratory judgment, and rescission. The trial court dismissed with prejudice on August 22nd, 2025. She appealed. The panel, presiding Judge Dillard, which judges Gobiel and Pipkin, opinion by Judge Gobel, affirmed on every count. A bill of exchange is not legal tender. Unjust enrichment does not lie where an express contract governs. Capital One is not an investment advisor under Georgia law. A contract cannot be unilaterally modified. Right there. Right there. And why is that so important, but it's so subtle? Because that really destroys any alternative methods of paying your bills under a contract. It destroys it. That's why I say, hey, whatever method, whatever process you're going to do, before you look at what you're about to do, look at your contract and see if it's authorized under the contract. You can't assume that it is when you have an express written contract where it's expressed and it's right there in your face where you can confirm. You can't assume or believe that you can or think that you can. If you are honest with yourself and you look at the contract and you don't see it, that means you can't do it. This is where discipline comes in at. This is to know when. This is why people get good in court. Knowing when to concede on arguments. Knowing when to concede on certain arguments. That shows that you're not bringing a bad faith litigation. Defendants concedes that plaintiff is allowed to do this. However, defendants understands that the plaintiff need not have personal knowledge of the software system used to produce the documents. Defendant understands that, especially pro se. That goes a long way for you in court, and it gets the judge to start taking your claims seriously. It's a known fact in court now. As soon as they see the word pro se, they automatically start to think sovereign citizen. They're expecting inaccurate case citations, They're expecting sloppily drafted complaints. They're expecting a lot of things to be wrong. Liberal construction of pro se pleadings does not manufacture a claim where none exists. So she was like, the court erred in liberally construing her claims. She was basically telling the judge to pretty much, if I'm doing it wrong, you do it right for me. If I made the wrong argument, all right, you construe it and make the right argument for me. And that's not what the courts are going to do. The court did something it did not have to do. It addressed her citations. As Capital One highlights, Hopson's briefs are replete with inaccurate citations, which due to their nature appear to be fabricated by artificial intelligence. The detail most readers will skip: Hopson's losing theories. Remember, it's not the fact that she lost, it's her arguments raised. And the arguments she raised are the same arguments still being promoted. Hopson's losing theories, bill of exchanges tender, securitization as security fraud, are precisely the theories a generative model will happily elaborate for you at length in confident prose with citation formatting that looks correct. The model did not invent the pseudo-legal theory. It did something arguably worse. It dressed the theory in fake authority, which converted a losing argument into a sanctionable one. That's all she did. That's what I'm saying. When you're being biased, you already have your argument in mind. AI will make the argument for you. What the court declined to do and what it promised next time. Capital One asked the panel to treat the fabricated authority as an abandonment of Hopson's claims. That is an aggressive ask, and it is detailed. Sophisticated defense counsel now understand that hallucination citations are not merely embarrassing, they are a procedural weapon. And yes, Ms. Hopson was embarrassed when she got the response, and she was hurt. I know I can see it now. She was very hurt because in her mind, she thought all the hard work she put in, all the time spent researching, all the things that she did, she thought she was on the right path. And for a judge order to come out and say everything that you thought you had right, you had wrong from top to bottom. And this is where well, if this don't work, then what do I do? And this what leads to pessimism now. And these are the people that you see online. They've already tried it so many times it don't work. So now they don't think nothing works. So this is where if you're saying anything different from what they believe, they're immediately going to say they don't work. They're immediately going to say you're wrong. They're immediately going, and it's that projection that's on the inside, their spirit, very negative spirit, very pessimistic spirit. You can tell it's projected in these online spaces. The court declined to go that far in this instance, but it issued a warning that every reader of this newsletter should commit to memory. All litigants, even pro se ones, are responsible for verifying what they file before this court. Her failure to do so has caused Capital One and this court to expend unnecessary efforts to discern her claims. Hopson is cautious that further use of fictitious legal citations may result in sanctions. The court then cited its own Rule 72, which authorized a penalty not to exceed $10,000 against a party or counsel in a frivolous civil direct appeal, and a Rule 7A, the court's inherent power. Translation: the next filer who does this in Georgia's Intermediate Appellate Court is being told in advance in a published opinion exactly what the exposure is. That is the through line of this entire issue. AI did not cause Hopson to lose. Her claims were meritless on the law. AI caused her to lose and draw a published warning with a 5-figure number attached to it. with a 5-figure number attached to it. Her claims were meritless on the law. AI caused her to lose and draw a published warning with a 5-figure number attached to it. Five rulings that should end the argument. Hopson is not an outlier. It is a data point in a line of authority that has been building since the summer of 2023. And the line now runs through trial courts, appellate courts, licensed attorneys, self-represented litigants, and in October 2025, 2 sitting United States district judges. Meta versus Avanica, Inc. 678F SUPP, 3rd District, 433, Southern District, New York, 2023. Judge Kevin Castle, June 22nd, 2023. That case started it. Counsel submitted a brief citing 6 non-existent judicial decisions generated by ChatGPT. Then, when challenged, produced fabricated copies of the opinions that the model had also invented. The court imposed a $5,000 joint sanction on the 2 attorneys and their firm. Takeaway from that case, the sanction was not for using AI. It was for failing to verify and then doubling down when the court gave an opportunity to correct. And this is the part where once it gets to the verification, this is where we're back at square one. Because if you don't already understand court, you don't know how to interpret case law, you don't understand the rules of procedure, you don't understand their applications to a particular case, you don't know the ins and outs, the nuances, the in-between. That's all the stuff AI is not going to do for you. See, it goes back to square one. Cruz versus Carlin. This was February 13, 2024. Pro se appellant. 24 citations in the appellant's brief. 22 were fictitious or misrepresented. The appellant explained they had hired an online consultant who claimed to be a California licensed attorney and charged less than 1% for normal legal fees. The consultant used AI. The court dismissed the appeal for Rule 8404 violations and imposed $10,000 in damages for a frivolous appeal under Rule 8419. It's not even like you use AI to find a correct case. The problem is the courts know when you don't really understand or read the case. You're not taking certain language from the case and making an argument of it. You're not breaking down the substance of that case and applying it to yours. They can tell, like, when you actually read the case, you're taking certain parts. Hey, in Johnson versus this, the court ruled this. And Johnson, on this date, he did this. He mailed this there. And the bank said that. And the ruling, the courts heard that. Similar with here. Plaintiff that did this and did that. What distinguished this from Johnson is that, you see what I'm saying? See, that lets the courts know that, oh, you actually taking it serious. You actually do. You actually understand. The key from Cruz versus Carlin, the key takeaway is a fake opinion is not existing law. A citation to a fake opinion does not provide a non-frivolous ground for extending, modifying, or reversing existing law. Shadid versus Assam, Georgia Appellate Court, June 30th, 2025, licensed counsel. A Georgia divorce case in which the trial court's own order rested on 2 fictitious cases drawn from a proposed order submitted by counsel. On appeal, the same attorney filed a brief in which roughly 11 of 15 citations were bogus. The Court of Appeals vacated and remanded and imposed a maximum $2,500 not frivolous motion penalty. Key language: the opposing party wastes time and money in exposing the deception. The court's time is taken from other important endeavors. Lawyers are doing it too. It is not uncommon to get someone to work, pay someone to work on your case, and all they do is just slap AI on it. And it's you want to use AI with your drafting and whatever you want to do, cool. But you still have to verify. You still have to make sure it's accurate. You still have to make sure it's legit. You still have to make sure everything that you're doing aligns up with the case. Like you still have to put human eyes on it. Like you still have to do that. There's still a lot of work that you have to do on the human side that you cannot rely on AI to do. It's so much work that you have to do. That's a fact. So much human work that you have to do. That's the AI shortcut. It got people thinking that everybody's a professional now. 1 second. Touching my shit. I'm back. Y'all the people touching my shit. We have another one. Maddox Burst Product Innovations Research. 11 separate pleadings. No, I'm sorry. Hold on. I'm missing one. Hold on. I moved too far. Nolan versus Land of the Free, LP, Licensed Counsel, a California Appellate Court, 2nd District, September 12, 2025. California's first published appellate opinion on AI fabricated authority. No California court has addressed this issue. The court imposed a $10,000 sanction on plaintiff's counsel, Amir Mustavavi, where fabricated quotations and non-existent authority appeared in appellate briefing. The court also observed that the respondent party never alerted it to the fabrications and appeared to learn of them only when the court issued its order to show cause. The takeaway: the fake citations survived all the way to a published appellate opinion before anyone caught them. Do not assume someone downstream will catch yours. Listen, lawyers are doing this shit day in and day out. Lawyers are doing, I've been seeing some arguments. Prime example, that last motion to continue filed by Lakeview, they made an argument on there in which the statute already foreclosed it. They made a frivolous, futile argument in which the statute says for discovery. Like even lawyers are doing it. So if lawyers are doing it, pro se litigants are doing it left and right. Give me 1 second. I got use facilities. 1 second.
What is written. You either gonna pay the tuition or pay for assistances or pay the mistakes when you case it dismissal. I come with everything that's under the kitchen sink. I haven't slept in a week. They scared while I'm willing to compete. These scammers are devils and I keep them under my feet. Ay, they saying they win, I never take their prescription. They never coming from the plaintiff's position. I am the blueprint, blatant admission. Check it when I talk classes in session. Professionals, even the tacos respect it. Show me a win, that's not a rejection. Tell me the truth without all the stretching. These gurus are boring and it's stretching. These students are dumb, desperate depression. Set you, yeah, I'm done with this lesson. Came from the streets, still I'm a step up. Run it up.
Thank you. I mean, and it's getting crazy, man. Like, case law. See, I'm from the old school. I'm from the old school of this. Like, I'm from the old school. I'm from going into the law library, pen and paper, writing cases down and taking notes on the synopsis of the case and finding the core elements of issues. Right. I'm from the pen and paper old school. When I came on this AI technology, man, I'm just now kind of getting live from it, man. It took all the way over the last few years. I was an old pen and paper, law library, case law, pen and paper writing. I'm from the old school. I take notes now. I don't even put notes in, the little app on the iPhone. I don't even put notes there. I get out my pen and paper. I do it the old school way. I'm old school with it. I am old school with it. I'm old school. Maddox versus Product Innovations Research LLC. This is the one that the court cited. 11 separate pleadings, summary judgment briefings, motions in limine, even a sanctions motion contain fabricated citations, quotations of law that did not exist, and misstatements. The court imposed a 6,000 punitive sanctions plus more than 23,000 in fees to the opposing party and delivered the line the Georgia Court of Appeals will quote 7 months later in Hopson. Before this court, artificial intelligence is optional. Actual intelligence is mandatory. One thing that can kill your credibility the rest of the way is citing a case that don't exist, miscite a case, misstate a case, or pretty much fabricate it. Because case law is case law. You got the opinion, you got the order. There's no way, like, if you mess that up, it's a tail. It's a tail. In October 2025, 2 federal district judges acknowledged that AI-assisted work by chamber staff produced error-written rulings. Yeah. Even the courts do it. The courts, the chambers, the staff. You actually think the court is going to read a 30-page brief? They got their staff. They're going to comb through it. Boom, boom, boom. Point it out. Take what you're saying. Take what statutes you signed. Read that. Verify the case law. Read that. But then read 3. Man, shit. Not in these, especially these debt cases where cases moving. Man, they may glance over your file the night before you got court, or when they get into the chambers, when they arrive in court in the morning. Judge Henry T. Wingate, Southern District, Mississippi, had a temporary restraining order that referred to non-existent allegations, parties, and declarations after a law clerk used perplexity to write it up. Judge Julian Xavier Niels, New Jersey, had a motion to dismiss opinion that misstated case outcomes and contained fabricated quotations after a law school intern used ChatGPT. Both withdrew the filings. Both responded to written inquiries from Senator Chuck Grassley, chairman of the Senate Judiciary Committee. Judge Wingate, it was a draft that should have never been docketed. This was a mistake. A lifetime appointed Article 3. If lifetime appointed Article 3 judges were law clerks, Westlaw subscriptions and institutional review can be taken by this. The proposition that a self-represented litigant working alone at a kitchen table will catch it by instinct is not a serious proposition. That is the go-to. When you don't understand ChatGPT, write it for me. What happens when you got to argue it? What happens when you're in open court? What? Nobody wants to talk about open court. Nobody wants to talk about being prepared for open court. They speak on court. It's just motions. What about in open court? Cross-examination. What about arguing your motion. Arguing your motion is not reciting the motion into the record. The judge already, they know what you wrote. They know what you put in there. They get it. They got the notes in your case. Judge says it's time to argue your motion. So let's say you had 15 citations and 5 arguments in your motion. And let's say it took you 3 hours to put that together. When it gets to argument, you may have 5 to 10 minutes. Why the motion be granted? The facts and circumstances, case law that you're relying on, and that's when you're going to have to quote the synopsis, give judge a breakdown of that case and why the reason it should be applied in this. AI can't, it's not going to do all that for you. Who is actually getting caught? There is now enough evidence to answer the question empirically rather than anecdotally. Oh, just one case, just 2 cases. I ain't gonna get caught using mine. Nah, I'm not gonna get caught using it. I'm good. The answer is not comfortable for the self-represented community. So, according to research, quote unquote research, 1,934 documented court decisions worldwide involving AI hallucinated content as of August 19, 2026. Of those filed by pro se litigants, 1,115 of those were filed by pro se litigants, more than the lawyers, which were 769. 1,325 United States cases, the largest share of any jurisdiction. Those figures come from the AI hallucination cases database maintained by researcher Damien Charlatan, which tracks only decisions in which a court expressly found or clearly implied reliance on fabricated material, not mere allegations. Recorded monetary penalties in the database run from a symbolic $1 to more than $46,000. The most common outcome is still a warning. That is what Hopson received. The trend line on warnings is not favorable. Read the pro se number again. 1,115 of the 1,934 cases were filed by pro se litigants. Self-represented litigants are the single largest category of filer in the global hallucination document, not big firm associates, not solos on deadline. Us. How reliable is the tool actually? Researchers at Stanford's Reg Lab and Institute for Human-Centered AI in Large Legal Fictions, Profiling Legal Hallucinations in Large Language Models, Journal of Legal Analysis, 2024, tested general purpose models against verifiable questions about real federal cases. Hallucination rates range from roughly 58% to 88%, depending on the model. 2 findings matter more than the headline rate. 1, performance collapses as you move down the court hierarchy. On basic tracks, the models were near perfect on Supreme Court cases and wrong as often as 83% of the time on federal district court decisions. Your consumer, servicing, or foreclosure dispute lives in exactly the part of the hierarchy where the model is least reliable. District court decisions, 83% of the time. Where it's hallucinating, it's right there where your cases are involved in. The models are psychopathic. The study found that they often uncritically accept users' incorrect legal assumptions. If you type your theory into the prompt, the model tends to build on it rather than correcting it. Yep. You don't think when they be holding classes live and videos and they got ChatGPT they teach it from, you think that prompt wasn't manipulated to tell it what they wanted to hear? That is the mindset of the masses in this space. Tell me what I want to hear. Don't tell me what I need to hear. Tell me what I want to hear. Tell me everything's going to be okay. Tell me that I'll be able to keep the house even though I'm 20,000 in the hole on it. Tell me that I'll be able to keep the house even though I just don't want to pay and I can't afford to pay and I have no real arguments, but making up these claims to justify not paying. The author specifically flagged the access to justice risk. Widespread adoption might unintentionally worsen rather than eliminate current disparities in the availability of legal services. Yeah. The polished penalty. The most important recent work is Orr, Cohen's, Sanctions, Artificial Access to Justice, AI and the Surge in Pro Se Litigation, University of Miami School of Law, 2026. An analysis of roughly 2.8 million federal findings. And nearly 13,000 linked pro se complaints. The court finding is a paradox that should be printed on the wall of every self-help law center. AI drafted pro se complaints look more professional than traditional pro se filings, and they perform worse. Higher dismissal rates, earlier termination, no greater success than non-AI complaints. That's what he said. Cohen's Sasson identifies two mechanisms. First, drafting difficulty used to function as a filter. It's the main thing right there. Drafting difficulty used to function as a filter. That is the part where when you start out with a blank screen, you got the caption, comes now, such and such appearing pro se, brings this suit to what? How do you word it? How do you draft it? Preliminary background, factual background on this, that. Nope. If you could not articulate the claim, you often did not file it. AI removes that filter and validates claims a lawyer would have talked you out of. Second, and this is the part that nobody warned you about, courts calibrate procedure to the assumption that one human wrote the complaint. Doctrines like plausibility pleading, Rule 11, and the liberal construction owed to pro se pleadings all assume an untrained author, aka they assume, they expect it not to be perfect. They expect a little errors. You pop up with an ironclad pro se complaint, they're going to be like, And this is one of the reasons why I watered down. I mean, I don't water down the merits. I don't make it sound too professional. I don't, I make it sound like, hey, Your Honor, I think this is wrong. I don't believe. I know I can put it, but it gotta make it read pro se. The judge caught that with my wife's motion. I tried to say it looks like a lawyer prepared it. I got a little nervous there because I know if they ain't just dismissed the case and she got getting challenged on the motion, she would have fell apart right there. I know nobody wants to talk about that part. Whatever is put on the paper, you have to be willing to, they're going to know. You have to know how to argue it as well. It can't be an ironclad motion and then you get in the court, you definitely don't know what's going on because everybody thinks that you can be shielded from your, imperfections just by motions back and forth, motions back and forth. What if you have an in-person hearing? Right. When the filing reads like a lawyer wrote it, judges quietly stop extending pro se leniency. Cohen Sashit calls it the polished penalty. When your shit starts to sound like they're not on pro se, nah. That's how the judge treated me. That's how Leona Brinkman treated. She did not treat me like a pro se litigant. In Hopson, the panel considered and rejected the argument that pro se status entitled her to more generous construction. That is the polished penalty in a published opinion. The volume problem and why the courts are losing patience. Reporting by MIT Technology Review, June 2026. Yeah, these are all these files. I have these files. These are in my files. These reports, you would be amazed at what's in my library, the files. You would be amazed how much professional reports published, faculty staff, different college faculty reports. When they do their faculty, put their joint reports out. And when they get the professionals to chime in, man, I have thousands of those from everything, law, court, legal strategy, the Uniform Commercial Code, the amendments to it, everything. Do you know how much professional documents I have? That's all I study. That's all I take advice from. That's all I read from. So if you're living in a professional world, you're reading these professional findings, these professional documents, these fucking got an MB at Harvard, sits on the board of legal justice at Yale, and you're reading their faculty, their staff, filed an amicus brief in a major bankruptcy case, goes all across the world giving seminars and teaching, and you keep reading their publishers, reading their findings day in and day out, always, you're going to start to think like them. You're going to start to argue it like them. You're going to put yourself on that level. Technology Review, June of this year, drawing on analysts of 4.5 million civil cases, found that self-represented parties rose about 11% of civil cases in 2022 to 16.8 in 2025, with filings more than doubling from pre-2023 levels because AI thinks everybody can be their own lawyer. Everybody thinks AI can be their own lawyer. If you're using AI and the AI just agreeing with everything you're saying, if you don't have an AI says, I can't type that, that is incorrect, that is legally insufficient, you're not going to get it. Look at all this case law here. See, because the mindset is confirm my bias, confirm my belief, confirm what I want to be true. A lot of these arguments people raise, they don't know if there's any legal merit behind it. They don't know. Before they put it on it, when they put it on the paper, they know they can't prove it. Factual, step by step, exhibits, they can't prove it. How can you prove your negotiable instrument paid the debt? What legal argument can you make for that in court? How can you prove just because you tender a bill of exchange that the debt's supposed to be discharged? How can you prove that you have the legal right to alter the terms of the agreements? How can you prove that? That's why they call it a waste of time in court. It's a waste of time. You know you can't prove half the things that you come online and argue me down about. You know you can't prove it in court. So when you know you can't prove it in court, now you want to prove it to me. I'm not the judge. Prove it to the judge. Prove it by the outcomes. That is actually verifiable. that actually has a proper case citation. That when we look up the case, it's not going back to another case. Like when there's a release of lien, you don't look to the left and the person's still filing a lawsuit against them. You got to release a lien, but you still got to file a lawsuit. Like, come on, man. Like, the shenanigans just got to stop, man. Shenanigans got to stop. The shenanigans has got to stop. It has to, man. It's getting nauseating. Chief Judge Patrick Schultz of the District of Minnesota has described the surge as an existential threat to the federal courts. Some judges see genuine benefit. Magistrate Judge Maritza Baswell, Democrat from Colorado, has said she can generally understand what they're arguing better with AI assistance from them than without it. Oh, yeah. Because the AI at least going to have it polished correctly. If it just leave it to them to word it, it's going to be fucking unintelligible ramblings. A lot of court cases, they're just rambles. You're just rambling, slapping a bunch of fancy buzzwords together like you're saying something. It is rambling. A lot of pro se litigants, it's not uncommon to the judge to always start a sentence off. Although hard to follow, we can best try to construe from what the plaintiff is trying to say. It's just rambling. Once you start talking that equity crap and equity what it is and the equity in courts and start citing, I sent the affidavit of non-performance of the notice of the performance before the performance needed to be due of the notice. You know how they have these crazy headings? Certificate of offset of the discharge obligations from the certificate of the security when the certificate of the certificated security was first created. Affidavit of actual truth and facts and the non-bias in the corporation of the United. Like a whole bunch of nothing rambles. Thanks for the gift, bro. Now, Magistrate Judge Allison Goodart, Southern District, California, is blunter about what the tool is doing to expectations. It is, she says, Dr. Google went to law school, describing chatbots handling litigates widely inflated case valuations. Both things are true. The clarity is real. The reliability is not. And the same MIT technology review analysis found that pro se litigants remain far more likely to lose than represented parties. A gap AI has not closed. Why the machine makes you feel like a lawyer. Part 4. The false confidence is not a bug you can prop your way out of. It is the predictable product of 4 things happening at once. I just seen someone trying to use Phillip versus Washington Legal Foundation. Interest follows the principal to claim their securities. There you go. There you go. There you go. Phillips versus Washington. There you go. Someone out there, yeah, I had 50 students. If I had 50 students accepted promissory notes for $1K each, I have $50K in receivables. I couldn't sell that note to a buyer or even a line of credit. It depends on what the market. You will have a market for. Let me see, for the promissory note, but it's going to be the collateral. It'll be if it's unsecured collateral, it'll be a risk. You probably would get like you probably got to discount the hell out of it, to be honest with you. Because you gotta look at the risk associated. Like if I want to buy it, what's the risk? Now here's the thing. If it's a legal binding agreement, then if it's unsecured, then you have court to enforce it. You get what I'm saying? So you can sell the debt. Yeah, you'll be able to, yeah. You'll definitely be able to sell it, but you might have to discount it a lot. Oh, yeah. You still make some money off it. And that's another thing about monthly payments. Sometimes monthly payments is good. You can still enforce the contract or whatever, get a judgment. Once you get that judgment, you can immediately send that to your employers and get a garnishment. So there's ways to collect. 1, the fluency reads as authority. Human beings evaluate legal writing largely by its form, the caption, the reporter site, the parenthetical, the signal, the confident declarative sentence, like that confidence. You see what I'm saying? Like, you know, the confidence sentence. A language model is optimized to produce exactly that form. It generates the surface features of authority with near perfect fidelity, while the underlying fact, does this case exist? Does it say this? Is a separate question the model is not reliably answering. You are grading the rapper. The rapper. You are grading the rapper. I'm sorry. So basically, you're grading the outside of it. But when you look to the substance, it's nothing there. 2, it agrees with you on purpose. The Stanford finding on contrafactual bias is the whole ball game for self-represented litigants. I'm going to say it again. The Stanford finding on contrafactual bias is the whole ball game for self-represented litigants. You arrive with a theory. You ask the model about your theory. It builds on your theory. In the adversarial system, the single most valuable service anyone can perform for you is telling you your best argument is weak. And that is the one service these tools are least inclined to provide. Opposing counsel will not perform it for free. The judge will perform it once at the end in an order. 3, and there you go right there. That goes back to they don't want to be told what they need to hear. They want to be told what they want to hear. They don't want to restructure their theory. They want to go with the theory as is. And they will fight anyone that remotely disagrees with the theory. Because that's what it's all is online. It's a theory. If everybody's theories was 100% true, and the way I'm doing is true, and Tom said the way he's doing is true, and this way is true, and everybody's just true in their own way, why is the success rate still so low? Number 3, there is no adversarial check before you file. A represented litigant's theory passes through a lawyer who is personally exposed under Rule 11 or its state analog, and often through a partner, an associate, and a site checker. A pro se litigant using a chat bot has replaced all of that with a system that has no license to lose, no fee at all risk, and no memory of the sanction. The certification on the signature line, however, still belongs entirely to you. Hopson says so in plain English, all litigants, even pro se ones, are responsible for verifying what they file. And they're not verifying the chat box. They're going to copy, they're going to get the words in the chat box, they're going to copy it onto a blank paper, they're going to copy and paste it onto a blank paper, they're going to print it out, they're going to sign it, they may glance over it, and they're going to send it in. 4, the theories most likely to be hallucinated are the theories most likely to be wrong. The model is least reliable on district and trial court authority, on state-specific doctrine, and on novel or fringe theories because there is little real authority to draw on, so it generates plausible-sounding authority instead. That is precisely the terrain of consumer defense, service and disputes, securitization arguments, and every discharge to debt theory circulating online. The emptier the doctrine cupboard, the more the model invents. Hopson's Bill of Exchange argument is the textbook case. Where the professional consensus actually landed. ABA formal opinion, 512, July 29, 2024. The ABA's first ethics guidance on generative AI does not prohibit these tools. It ties them to the existing duties of competence, confidentiality, communication, supervision, and reasonable fees, and made clear that the output must be independently verified by the lawyer. That's the problem there. Y'all not having y'all stuff independently verified with a third and interested party who's going to give you the cold, hard reality because it costs them nothing to lie to you. They get no benefit from lying to you. They get no benefit from telling you what they want to hear, and they're an uninterested party. Y'all are having y'all documents reviewed by people who think like you, who, regardless of what they see, they're going to agree with you. There's a difference. You can pass your off to your little legal buddy. Y'all on the same panel together. Y'all cool, buddy, old buddy, old pal, old friends. And he gonna look at your motion and be like, yeah, that's cool. Yeah, I like that. Pass it to me. I be like, bro, the court did not say this. This case has been overturned. You didn't satisfy this element. You see there's requirements here. You didn't meet that burden. No, that's worded wrong right there. No, you're opening the door for them to counter. Man, I disagree. I think it's right. I've done it to people already. Very few has been like, oh shit, man, appreciate you keeping 100 with me. Now I'll be like, here's the citations. Here's the source in which I relied on. Here's the authority here. You want more? Here's the authority. Here's the case law. Here's the updates. And that's and besides the few people that do that, the rest, now I disagree with your finding. And it's not because they actually disagree. It's because to them, I'm attacking their belief system. To them, I'm telling them, you're not going to win. To them, I'm being negative. There's no such thing as, oh, be positive or you're being negative in court. It is what it is. If it's either a legit argument or it's not, there's no hope. That's what y'all want. Y'all want hope. Then when you get the orders you don't like, now you want to claim the judge's conspiracy theory. Oh, they're out to get you. You're doing it to yourselves. Dozens of federal judges have entered standing orders requiring disclosure of AI use and certification that citations were verified. The District of Kansas issued one in 2026. Several state courts, including Oklahoma, have adopted formal rules. Note what none of them say. No one says the tool is banned. Everyone says the human signs for it. The professional consensus is not don't use AI. It is you are the verifier, and there is no one behind you. Not saying you can't use it, but God damn it, you better be careful. How many times have y'all used AI to draft your response and it didn't go as planned? See, that's another thing. Nobody wants to talk about the losses too. Nobody wants to talk about, they don't even want to pop up online when they got to win. They only want to post about what they just filed. They never post the other side's response. But when they respond to what the other side just said, oh, now they want to make a video about it. What about what the other side saying? So you get their side, you get your side. I'll make more of a good showing. This is why I don't have a problem reading the responses for people like Lakeview, Lone D. I don't mind reading their response too. As I do. I don't just show you what I filed. I show you what they filed too. So we can track. We can see what's going on. Everybody is scared of the one thing that you cannot control in court. Everybody is trying to protect the stigma of a guaranteed win in court. You play around court long enough, you're going to have to end up going on appeal in one case. That's the risk. That's the gamble. That is how the game is played. There is no such thing as a 100% wins in court. There are lawyers who've been doing a lot of this shit before a lot of us was born, and they don't have 100% wins. Top professional lawyers in the world, their firms have taken L's. They've lost at jury trial. They lost on appeal. You figure out what you did wrong, tighten it up for the next one, shake it off, keep pushing, discussing the case with your colleagues, discussing it with your people, seeing, tighten up for the next time, because that's court. Because there's going to be another one and another one, and you can lose that one, and you can lose that one again. What are you going to do when it happens? How are you going to respond? How are you going to bounce back? This fake 100% wins. It's lies. It's a scam. 100% guaranteed. It's a lie. It's only two things that's guaranteed in this life: death and taxes. The former is more guaranteed than anything. And if more people would start discussing the whole case rather than certain cases that they want to show, just one, they will never show a lost case. The way they put it online, that there's no appellate courts. Everything's supposed to be done at the trial level. There are no appellate courts. If that's the case, why do we have appellate courts? To appeal the judge's decision if you believe the judge got it wrong. You got to be realistic when it comes to court. You got to go over all possible outcomes. You can't just rely on a theory and then base your proposed outcome on the theory that you want to argue. And that's what I mean. You ain't been around court long enough if you don't understand what I'm saying. You ain't been around it long enough. I done seen cases flip on top of their heads. One hearing. I done seen all out, toe-to-toe slugfest between both parties. Countering, volleying, back and forth. Sat through it. There are times where the judge is going to rule against you, no matter what. There are times. Where they just gonna be like, whatever, yeah. That's court. This fake online. Oh, look at. In 2004, look, you lost here. Hold on, 2009, you lost here. Look, 5 years ago, look. You don't understand court. Everybody's so quick to hide for the expose. Transparency exposes itself. Trust me, you don't need to expose it. It's already exposed. And what you're teaching today I can't fault you if you was teaching something 5 years ago, but you're teaching something today totally different. That's 5 years ago. What are you doing today? We talking about what your argument. I can't keep go back 30 years ago what someone did. Cool. All right, that shit ain't work either. You gotta, where the progression at? Because if it's a person that started their career out, lost their first 5 cases, and you look at them today, they like 78-7, won 20 cases in a row. That shows growth. I mean, that's what you're supposed to be doing. You're supposed to be growing. You're not supposed to be relying on claims and theories from 5-6 years ago. You're supposed to be updating them. You're supposed to be growing. You're supposed to be progressing. Would you think you're going to progress in this system and you don't take no L's along the way? No bumps on it, you know, that you ain't got to take it on the chin? And that's the problem. A lot of these people, you got glass chins. You are so scared of the laws that you do everything to try to prevent it, but you're doing everything to usher it in sooner. Everybody's so scared of losing. They're so scared of being looked at as a failure. They're so scared to being looked at as a failure. They're so scared of what other people are going to say about them. I could give a rat's ass. They wish they can be this free as me. Oh, the teachers are in a box just as much as the students, and the teachers, and they in mental prison too. They want to be so much more honest than what they are, but they feel like if they come out and be honest, it's going to bruise it's going to slow their money down. It's going to stop, so they got to keep it going. See, I don't have that issues because I never came on here solely like, all right, I'm just going to make money off this shit. It's all about the money, 100%. See, that was never my mindset. You're scared. Stop being scared. How to use it without getting sanctioned. Nothing in this issue is an argument for abandoning the tool. It is an argument for demoting it. A language model is a drafting assistant and an explainer. It is not a source of authority, and it must never be the last thing that touches a filing. The 7-step verification protocol. 1, open every case, every single one. If you cannot pull the full text and read it, you cannot cite it. No exceptions. No, it was probably real. 2, confirm 4 elements independently. The case exists. The reported volume and page are correct. The year in court are correct. And the case actually holds what you say it holds. Fabrication is not the only failure mode. Real cases misdescribed are just as sanctionable. And that is what happened in Shaheed versus Maddox. Verify every quotation character by character against the opinion. Invented quotes inside real cases are the hardest hallucination to spot and the one that most reliably draws sanctions. 4, use free primary sources, court listener, recap, Google Scholar, case law, Justia, deciding court's own opinion page, and Pacer for federal documents. Your state's appellate court publishes its own opinions. That is the authoritative copy. This is why I don't understand, because they're not doing the work. They're using AI as a shortcut for doing the real work. Everybody wants the outcomes. Everybody wants the property free and clear. Everybody wants the title. Everybody wants the lien release. Everybody wants the debt to just go away. Are you doing the real work? That's the difference. The bigger and grandiose the outcome you want, the more and the harder you got to prepare for it. The bigger and grandiose the outcome you seek, the more and the harder you got to prepare for it. You want a house or vehicle free and clear, title, you got to work your ass off for it. You got to prepare for it. Nah, I see the document output. I see, you ain't taking it serious. You may think you are. It's only serious when you're being sued. That's why I said you was so important, because it's more of a mindset thing rather than a reactive defensive thing. How many times do you see people get interested in this stuff only when they're being sued? Only when there's a judgment, only when there's a summons. Why isn't the same way you're going to start studying, trying to learn this stuff like your head's on fire? Then where was the same fire and desire when you were current? That's a mindset thing. That's a mindset. I came through the door with that mindset. When have you ever seen en masse online lawsuits being filed while there is nothing on the account to dispute when you're current? Oh, when you're current, there ain't nothing to argue. Factually wrong. Nope. That's where all your some of your best arguments is that position right there. Number 5, check that the case is still good law. Existence is the floor, not the ceiling. A real case that was reversed, vacated, or superseded is a different kind of problem. 6, never accept a citation the model produced without being asked. If you did not supply the case and then verify, treat the citation as fabricated until proven otherwise. Ask in the chat box, are you sure these are real? Is not a verification. It will confirm its own invention. Read your own brief aloud before filing. If you cannot explain what a cited case held in your own words without looking at the AI output, remove it. You are certifying it. You will be the one standing in the courtroom. See, this is all the things that people think AI is going to do for you. Want to replace AI with the real legwork. Safe uses, honestly stated. Explaining a doctrine you are trying to learn, then confirming it against a real source before you rely on it. Organizing and tightening prose you already wrote. Structure, clarity, tone. This is where Judges Braswell's observation about improved comprehensibility is real. Producing a checklist of what a rule or statute requires, then reading the actual rule text yourself. Stress testing your own argument. Stress testing your own argument. Stress testing your own argument. But only if you explicitly instruct it to argue the other side hard and you take the result seriously. So stress testing your own argument necessarily is you looking at your own complaint, looking at case law, looking up adversarial case law, looking up the other side. How do they usually respond to these? Let me see what lawsuits they've been involved in these claims. What they gonna do? How they say? Being given a 100% clean and honest observation of your own case. You cannot be real with anyone else unless you're real with yourself first. The unsafe uses, equally honestly stated. Asking it to find cases supporting your position. This is the single behavior that produced nearly every case in part 2. Another unsafe use. Asking it whether your legal theory is good. It will most likely tell you yes. It told Hopson yes. Let it draft a filing you then submit without full independent verification. That's the whole space here. That's it. Paying an online consultant who is doing exactly this on your behalf. This is the Cruz versus Carlin, and the 10,000 landed on the litigant, not the consultant. The one sentence to carry out of this issue, the chat box does not sign the certificate. You do. And when the court asks who is responsible for what was filed, there is only ever one name on that line. Sanctions at a glance. And these are all the sanctions. Metaverse, 5,000 out sanctions. Cross, 10,000. Shaheed, 2,500. Nolan, 10,000. Maddox, 6,000 plus 23,000. Wingate, withdrawn. Hopson's warning. And these are the sources. Hopson versus Capital One. Metaverse, Avianca Inc. Cruz versus Carlin. Shaheed versus Islam. Nolan versus Land of the Free LP. Maddox versus Product Innovations Research. Damian Charlatan. His AI hallucination cases. And yeah, case. So this will be uploaded. This will be uploaded. This will be uploaded on the Patreon. As far as the newsletter series, that will be uploaded on Patreon as well. Well, I got another one that's being uploaded, and it's a woo-wee. It's a doozy. But yeah, man. Yeah. It's getting crazy, man. It's getting crazy. If y'all ain't know, the Tupac murder trial, Keefe D, it's day 4 of the Tupac murder trial. Just in case, it looks like there may finally be some resolutions in that case, which is almost 30 years old. So let me see how this plays out. How to use AI.
On June 19th, 2023, defendant Benjamin Lamprecht was charged with operating while intoxicated and operating with a prohibited alcohol concentration in the Burnett County Circuit Court in Wisconsin. This was Mr. Lamprecht's third OWI offense. Mr. Lamprecht was given the opportunity to participate in the court's so-called Intoxicated Driver Intervention Program, or IDIP, which is designed to help defendants with 2 or more OWI offenses change their behaviors related to alcohol and drug use and receive impaired driving education. Participants who successfully complete the program can receive benefits, including reduced jail time, fines, and license revocation periods, and they may also avoid being placed on probation with the Department of Corrections. Over the next several months, the court granted multiple continuances to allow him to complete the program requirements, which were not finished within the amount of time that was typically allotted for the program. After rescheduling several court dates, a plea and sentencing hearing was scheduled for June 25th, 2024 in the courtroom of Judge Melissa Mogan.
Now, again, you understand that I'm not bound to follow any recommendation, and that would include following the IDIP guidelines.
Yes.
I could sentence you all the way up to the maximum possible penalty, again, if I thought it was warranted. You understand that?
Yes.
Do you have any questions for your attorney or the court before we proceed?
All right.
And that's all kinds of fun today.
Sorry about that.
Any questions?
Just one. It's just kind of a math question. I just want to know if it's fictional or fact.
Math is usually not fiction. But it's math.
And yeah, so I'd just like to be explained, like, how the math works. So I'm pretty good at math.
You want me to get a math professor in here to explain it? Because I'm not a mathematician.
That's what he said.
That he's not a mathematician because he's not. Because quite honest, we go to law school, so we don't have to do math. But we have to do math in our job. What's your question?
There you go. They go to law. That's what I said. You're rarely ever going to find any person that knows securities law, accounting, consumer transactions, autos, mortgage, and legal. Not all in one. A securities law person, he gonna know securities. An accountant knows accounting, math, legal, law, they do that. Rarely ever do you know a lawyer that also knows accounting, that also knows securities. You get what I'm saying? It's different, separate industries, but they all interconnect.
Just to know if this is fictional or factual.
I don't know what this is.
Would you like me to?
No, what is this, Mr. Keene?
I think it's wait. The issue, and it's been up with Ms. Anderson and I, is he had a question about the grams per 100 milliliters.
Dude,
and
that's a scientific question. You can call up the scientists or the lab analysts that do that. I'm not in charge of that. And the legislature makes up the laws. I'm in charge of following and enforcing the laws.
Okay.
So what's your question? You think that you were below the limit, above the limit, beyond the limit, how they came up with the limit?
According to this, I was not above.
Okay, and that's like a AI chatbot thing, right?
Yeah.
So yeah.
Maybe it's wrong.
Yeah, it is.
An AI chatbot?
But
are we using?
So he used an AI chat box to contest, I guess, the grams or whatever, the drugs or what he was drinking, his levels. So he put that in AI. I told you, the first thing that people run to is goddamn AI. They run to ChatGPT and try to decipher what's being said in that. No, it doesn't work that way.
Yeah, maybe it's wrong.
Yeah, it is.
An AI chatbot?
But
are we using artificial intelligence?
It's just that I was measured in thousands, and the law goes by hundreds.
You can have a trial if you want.
I am so great to have a trial. I love having trials, especially when the lab analyst comes, and especially when then it completely opens up to the maximum penalties. That's great and fine with me. Is that what you wish to do, and have a lab analyst up here to explain all of the scientific reasoning behind the calculations and behind their testing?
Just take me to jail.
There you go. See? Well, ChatGPT said that my levels was lower. You think ChatGPT is going to override that scientist, the one from the lab that goes on there and explains it? You think that ChatGPT is going to be more credible than that person from the lab that's going to come and explain? That's probably been there forever. You think ChatGPT is going to overcome that? Huh? ChatGPT.
Okay, I think that's his way of saying he's not rushing to press the point, Your Honor.
All right. Did you review the criminal complaint with your attorney? And it has all of those facts that says what happened that day from the officer's perspective and from your perspective, because you said, I only had 1 or 2 beers, which we know isn't factually true.
No, I had 0. I had drinking the night before.
So then you drank a lot more than 1 or 2 beers the night before.
I had a six pack of 16 ounces and a 16 ounce
and yet you blew a .221 allegedly in the criminal complaint.
Yeah, and that's what I'm saying is that 221 is thousands, not hundreds.
Oh, Mr. Lamprecht, it's .08 in Wisconsin to be legally drunk. And for 1 or 2 beers or a 6-pack or whatever you said the night before, unless you are a chronic alcoholic who drinks all the time, you won't wake up the next morning to blow a .221. It's impossible.
Exactly.
But you did. And we have lab, right, Mr. Renicky?
We have a lab.
What does lab say? Where they tested it with scientific stuff.
I didn't mean to put you in a bad mood.
0.19. You did by starting by being late. Okay, you're not supposed to be late to court. Okay, you're supposed to be here early so you can meet with your attorney. And quite honestly, and it's taken you months and 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 months to do the IDIP program. I gave you yet another chance, and now you're here debating.
I'm just saying, anytime you put a numeral behind the decimal, like 1 numeral behind the decimal is a tenth. 2 numerals behind a decimal is 100th.
Yep.
3 decimals behind 3 numerals behind a decimal is 1,000th.
Yep, I know math.
Okay, and 1,000th is 10 times less than 100th.
Well, let's cut that off. Okay, you blew a .22 with a PBT.
221.
or 0.221, okay? So you were 0.22. We'll give you the benefit of the doubt. No more with that one, that thousandth, gone. So you blew a 0.22. But lab came back and said, guess what? We ran his blood, which is more accurate. And it gave us a better truth of what happened. And it was 0.19. It's 0.08 in Wisconsin to be legally intoxicated and operate. So you get it now? You understand now?
I don't understand how 1,000 is 100.
Based on his AI research, Mr. Lamprecht argues that his blood alcohol concentration, or BAC, was not over the legal limit because his BAC was measured in thousandths, and the statute setting the legal limit uses hundredths. This argument demonstrates a fundamental misunderstanding of basic mathematical principles. In decimal notation, each digit to the right of the decimal point represents a fractional part of one whole, with tenths in the first place, hundredths in the second, and thousandths in the third. The more decimal places that a number has, the more precise it is. For example, 0.221 means 221 thousandths, which is equivalent to 22.1 hundredths. 0.08, which is the legal BAC limit under section 340.0146M of the Wisconsin statutes, equals 8 hundredths or 80 thousandths. Therefore, a BAC of 0.221 is not smaller than 0.08. It is nearly 3 times higher, making Mr. Lamprecht's argument grievously misguided.
I cut that off.
And that's what you get for the put. So he think 0.221. Man, that the legal limit is 0.08. It was 0.221. That's more than the legal limit. But ChatGPT said, no, the court got it wrong. You wasn't drunk. It's really this. They use 1,000th, especially used by the hundredth. The 1,000th is less than 100. But no. Nah, ChatGPT said that he was right.
It's 0.22. It's 0.22.
No, if there's 3 numerals, because if it was point.
Mr. Renicky, I'd love to have a jury trial because it sounds like he doesn't understand the science and he wants to have a lab analyst here. Is that right, Mr. Keene? Is that what I'm hearing? He wants to have a jury trial because we can facilitate that next week.
I'm just saying what math.
I had
No, answer the question. You trying to get it argued down now, but when it comes, you want a jury trial. Oh, I don't want a jury trial though. No. Go to trial, stand on your ChatGPT argument. And you sound like you're drunk. You look like you're drunk now. You know you was over the legal limit, but ChatGPT, stand on it.
Had a jury trial come up, not next week, the week after. We can get a jury trial. Is that what you want? You want to fight that issue of this extra thousandth in the decimal point?
It's not an extra thousandth, though. It's 1,000th or it's not.
Okay.
Answer. Oh, this fucking idiot.
It's 1,000th or it's not.
Yeah.
You want to go to trial over that and have the lab analyst explain it? Because I'm going to tell you, she is far smarter than I am when it comes to science and to explain it to you. Then maybe you'll be able to understand. You won't be able to ask your questions.
How about this? Can I just go to jail and I'll give you this copy?
I don't need the copy.
Okay, and then just give me the knowledge because I like math. And
here's what you can do to gain knowledge. Call up a lab analyst, have them explain it to you. Because that's what happens in a jury trial. And I hear it. It goes on for hours.
I'm not trying to piss you off. Just take me to jail. I'm fine with that. I have the money finally at the last moment. You've been very giving, lenient with me and giving extensions. You're fair. And I'm here. And I'll go to jail. Get out. I got a job.
All right. So are you admitting that you at least blew over a 0.08 or at least 0.08, at least blood alcohol content was in your blood at the bare minimum?
I agree that I blew a 0.221 and I agree that my blood alcohol was at 0.190.
Okay. All right.
I agree with those.
And
you idiot. It's oh my God.
Do you agree that you operated or drove a motor vehicle in that state?
I agree to that, yes.
All right, Mr. Keen, may the court use the probable cause section of the criminal complaint to find a factual basis?
Yes, Your Honor.
Has anyone made any threats to you, Mr. Lamprecht? Any promises for you to plead guilty to this charge? Has anybody promised you anything? Hey, we're going to give you $1 million if you plead guilty, or we're going to give you some kind of benefit if you plead guilty, other than this offer of guidelines?
The only thing that I've been told was that I can get out, keep my job, keep my place, and keep my thing.
Okay, so that's not a promise. Anyone threaten you anything? I'm going to beat you up. I'm going to take a gun. I'm going to take a knife.
None of
Anybody threaten to hurt you or anything?
None of those.
Okay. You're pleading guilty with a full understanding of what you're doing here today?
Yes, I'm pleading guilty to blowing a .221 and having a blood alcohol content of 0.190.
All right. And count one, how do you wish to plead?
Guilty.
Court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of count one. Count two will be merged and dismissed with count one. A judgment of conviction will be entered today. Mr. Renicky, argument, please.
This is kind of amazing, but in any event, this is an OWI. There was bad driving, but no accident. As the court is aware, it's a 0.19 BAC. This is his third OWI. He did complete the IDIP program. He still has to, at least at the time of my letter from Tessa Anderson, he had just dropped off the last $200 to complete the IDIP, but he needs to come up with a down payment for the electronic monitor as well as the booking fee. He was booked and released, so he has not set the 48 hours. Because of the IDIP completion and consistent with the plea agreement, we would ask the court to follow the IDIP guidelines for the 1-9 on the third offense, which I believe is $1,911 for fines and costs. That's a blood draw, so there'd be a $10 blood draw, 45 days of jail, 24 months of ignition interlock, 75 hours of community service, and 24 months of revocation.
Mr. Keen.
Yes, sir. I think this agreement recognizes both that alcohol use is an issue in the community. It has provided some rehabilitation needs because he has done some community service to deal with the harm to community. Although again, no accidents happened. He was, for the period of the IDIP, which is longer than normally, done by the court by a substantial factor, had to. The court should stick with the agreement. Mr. Lamprecht has met the terms of the IDIP, albeit not in the normally prescribed time. The agreement does serve the goals of trying to get pre-sentencing rehabilitation done, and there's substantial deterrence to protect the community's interest because of just the fact that it's an OWI-3 and the ignition interlock provides that for 2 years, plus the substantially greater penalties on any future sentences. So I would ask the court to stick with the agreement despite the less than beneficial behaviors at times exhibited by Mr. Lamprecht.
Thank you. Mr. Lamprecht, anything you want to add or say to the court?
No, nothing that I haven't already.
Well, what are you doing employment-wise and stuff that you're trying to help the community?
Yeah, I have a job.
Okay.
He has a job, he has a life, he
Yeah.
is there waiting for him after he's done here today, which is all a positive thing. It's all about rehabilitation. OWIs are very serious. I don't make the law. The legislature makes the law. I don't determine the science. The lab analysts who go to school for years and years and years and years and years.
AKA the professionals. Not saying human beings ain't perfect, but God damn it, they draw your blood. It's hard to defeat that. It's your blood. It's in your body at this time. Now, there may be faulty results. Yeah, it's few far in between. And key word, the legislator made the law, meaning the state legislators authorized by the state constitution with further authority given by the 10th Amendment. Did you ever hear about driving while intoxicated mentioned in the Constitution? Was that expressly mentioned in the Constitution? So no, the power to make laws govern intoxicants and driving while intoxicated or drunk driving or whatever, the states have the right and the authority to govern the safety and welfare of its citizens. So that state law is just as valid as any one of those federal laws that you want to cite. You have to abide by state laws as well. You can't use the federal and the Constitution to try to override and bypass state laws that you don't want to adhere to. I find it very interesting how everybody want to say state laws ain't nothing, but when you file your lawsuits, you're filing them in a state court that it's not an Article 3 court. So remember, they don't have no, what is it? It's not legitimate tribunal. Then why are you filing your lawsuits there? Why don't you go to the Moorish or the Sovereign or the social media law courts where they recognize your arguments? Y'all always, you don't recognize this stuff, don't recognize the rules, but you don't have a problem filing a lawsuit. You got no problem asking the judge who has not shown his oath of office or delegation of authority, even though they're impaneled and sworn in. You don't have a problem asking the judge to give you something you want. But whenever it's time to take the other side of the coin, now the judge is not qualified to do it. Find that to be very interesting.
The lab analysts, they learn science and they learn how to read scientific data. So they are the smarter ones in the OWI matters. I know the law, I see the law, I read the law, I enforce the law. I ensure that that the community is protected in certain ways. OWI is, again, serious. You're putting yourself at risk. You're putting others at risk. The fact that you blew a 0.221 at blood alcohol content from blood at 0.19 is serious, especially given
190. Sorry for interrupting.
Don't interrupt me again. You interrupt me again, and I will hold you in contempt. I will hold you in contempt, and I will ensure that you have more jail time than what's being sentenced here today. All right?
I like you, and you're a fair judge. I'm not trying to piss you
Then
off at all.
stop talking. Okay. I need to ensure that the public is going to be protected, and that means to ensure that you've learned a lesson, you're rehabilitating, you've done the IDIP program. That's a positive program. It's taking.
Anytime someone says, I'm not trying to, and it's followed by the same act that they say that they're not trying to do, yeah.
More than most to do that program, but you've at least completed the program, which is positive. You're going to have the ability to get your license back or get an occupational prior to the end of your revocation. Your attorney is very correct. The next OWI will be a felony. The one after that is mandatory minimum prison sentences. So it's very important that you figured it out now and that you're not going to engage in this type of behavior before or again.
Judge Mogan explains to Mr. Lamprecht that if he is convicted with a fourth OWI, it will be a felony offense. Under Wisconsin law, the penalties for operating while intoxicated increase sharply with each subsequent offense. The first 3 convictions are misdemeanors, with increasing fines and jail time for each offense. However, under Section 346.65 of the Wisconsin statutes, a fourth OWI is classified as a Class H felony, punishable by a minimum fine of $600 and at least 60 days of imprisonment. In addition to these criminal penalties, a felony conviction can also carry lasting collateral consequences, such as the loss of certain civil rights, restrictions on employment and housing opportunities, and limitations on firearm possession. This escalation in penalties reflects the state's intent to treat repeat OWI offenses as serious criminal conduct, marking a clear distinction between misdemeanor and felony level drunk driving.
What I will do.
And no, you can't run to the federal courts and say, federal court, I don't like that. I got to serve the consequences for this felony. I want you to do something about it. Federal courts is going to say, shit, we ain't got no jurisdiction. You better go deal with them. Since federal courts always trump state law. Right. Of course.
Is I will follow the IDIP guidelines. Despite all of the issues in this case, I'm going to follow the IDIP guidelines. I'm going to assess $1,911 in fines and fees with an additional $10 blood draw fee, 45 days in jail, 24 months of ignition interlock device to be placed on any vehicle you drive. Doesn't mean you need to own that vehicle. If you're going to borrow your mother's vehicle to go down the street to the gas station, it must have the IDIP in it or the interlock in it, or you may not drive the vehicle. 24 months of revocation of driver's license, OWI assessment and driver safety plan, 75 hours of community service. If you wish to convert the 75 hours to additional jail time, you can do so. Talk to Ms. Anderson. She will ensure that the court gets a letter, and you must pay for it's an additional 8 hours of community service for 1 day of jail time. So it's an additional $18 a day that you would need to pay if you wish to convert any community service to additional jail time. Immediately report to jail. And that means that you will have to go sit 48 consecutive hours before you are eligible to be released on monitor. I'm going to tell you, this is where I'm going to be very clear with you, Mr. Lamprecht. I take no excuse. If you are going to be released on monitor, you must prepay at least 30 days in advance. If you are even 1 day late on payment for a 30-day advance, you must sit in jail. You don't get additional time. This is where I'm very serious. You blow even a 0.00000001 with anything with alcohol, that's a violation to me. You will be immediately terminated off of the monitor. You will immediately report to jail, and you will sit the whole sentence. No good time, no Huber. I was near rubbing alcohol. I ate bang bang shrimp, okay? I take no excuse. It is an immediate report, no good time, no Huber.
Judge Mogan sentenced.
She is not playing. She is not playing. She is not playing.
According to this, I was not above.
Okay, and that's like a AI chatbot thing, right?
Yeah.
Is HOA fees by the HOA, and this is resulting in him being overcharged compared to some of the other residents. The motion for sanctions, I'd planned on getting into a really descriptive explanation of what happened. However, plaintiff has filed a response to our motion for sanctions, I believe on Tuesday, or perhaps it was yesterday. In that response, just to summarize, counsel basically admitted his conduct, fell on his sword, and has addressed the issues, agreeing that there were false and fictitious citations. So in plaintiff's original response to our summary judgment, he cited to a single case for multiple propositions of law, about 6 different propositions of law supporting his arguments. And he even pulled a direct quote from that case. On my screen, that case is In re Christopher Kapmeyer. It's a 1-page opinion, but it does not contain a single one of the propositions of law that plaintiff relied on. Giving plaintiff counsel the benefit of the doubt, we searched for another case called In re Kapmeyer. We were able to locate it. There is a Supreme Court case with that name. The recorder and other identifying information is not what was cited in the motion, in the response. And this other In re Kapmeyer case only deals with, it's a joinder issue, and does not contain any of the legal authority. So a week prior to the summary judgment hearing, we sent counsel a letter, which is Exhibit C, which I'm showing you, just explaining that, we were unable to find it. We think that, the citations are incorrect. And we asked that he either send us a copy of the case, send us the correct citation, or resolve the issue. We never heard back. All we got was a second response to our summary judgment, completely removing all citations to Kapmeyer, and then citing a host of new cases. And in the second response, again, there were multiple issues, fictitious citations, what we believe are AI hallucinogen cases.
This is a goddamn attorney embarrassing himself. This is a goddamn attorney withdrawing the first hallucination and then added more. This is your ChatGPT. This is your, say that this is what the report was about. This is your ChatGPT. So if attorneys are falling victim to this, what makes you think the average pro se litigant out there thinks that I don't need to consult, confer with anyone who understands court because I have ChatGPT right here. I can save money and I can do it myself. The problem is the do it yourself is always going to come at a cost and expense to your most valuable possessions when you're doing it yourself and you're still actually learning at the same time.
And there was at least 3 cases that we identified that either a direct quote was pulled from that does not exist. The recorder number took us to a case that is not the case that was cited. And then there was another quote that did not exist. However, in our opinion, the most concerning case was a case called MBM Financial Corp v. The Woodlands, which plaintiff cited to as a Texas Supreme Court case. Plaintiff at the hearing in front of Judge Burgess stated affirmatively to the judge that this case recognized an ongoing economic breach as giving rise to a recurring cause of action, essentially arguing that every time Mr. Pacheco was assessed, it either told or reset the statute of limitation. This case does not mention that. Counsel made the affirmative representation at the hearing that this case was Texas Supreme Court case law. It was controlling law. The reason that this case is so important.
Bruh, you miscited controlling Supreme Court law. How do you get a Supreme Court case wrong? Oh my, embarrassing. Embarrassing.
Due to its miscitation. And in fact, that case really only stands for the proposition that attorney's fees can be awarded in addition to nominal damages or something along those lines. And that doesn't even talk about this recurring violation rule, which again is not an actual Texas doctrine. But at that hearing, once this case was cited, I brought it up to Judge Burgess and said, Your Honor, I should have addressed this probably at the beginning of the hearing, but we believe the citations from this case are false, or there's hallucinogens or any of the hallmarks of generative AI being used. I don't think the judge understood the allegation that I was making, because his next question to me was essentially, well, do you have a Supreme Court case that rebuts that proposition of law? And then shortly after that, he denied our motion after we had a discussion about whether the continuing violation doctrine existed or not.
So, Judge, I want to address it directly. I put it in my response. The earlier filings did contain citations that I didn't verify properly. It shouldn't have happened, and I take responsibility for that. The issue is twofold, however. One is the citations may have been wrong, but the principle of law is correct, and that's addressed in the response to the MSJ on the merits. And the other issue is really whether this rises to the level of sanctions. I think the facts as described don't show conscious wrongdoing. I do believe that they show mistake or negligence. Chapter 10, similarly.
Mr. Lee, let me interrupt you for just a second. Did you use AI to come up with your response?
I did. I used several tools in order to do the research. The drafting that I do, I draft by hand myself, but I do use available technology in order to, to do my work.
There you have it. There you have it. Now, he says he drafts his by hand, but he used AI technology to, I guess, do a lot of the work, or probably formatting, probably research. See, in the social media pro se spaces, they use AI for the whole 9.
So you understand the obligation of counsel, if you're going to use or utilize AI, is to actually check the citations and the quotations that the AI provides.
Totally understand that, Judge.
If you were in federal court, what do you think would happen to you?
Oh, you would have got sanctioned. You would have got sanctioned in federal court. You would have got sanctioned. Most definitely.
Judge, I can't quite say I don't practice in federal court. I'm sure it wouldn't. I'm sure it would be as uncomfortable and difficult as it is right here today. At the time of the filing, I didn't independently verify that because it was such a truism that, you can't have a summary judgment on,
Don't start justifying using.
Right. No. Now you're trying to get to the elements and the facts of the case. This is an embarrassment. This is a travesty for a licensed attorney to not only use AI, but to actually don't even independently verify the citations. I'm sorry, I gotta say it. This lawyer is doing everything that I would tell y'all not to do. I will never tell you to not independently and this is the problem. If you don't understand how to read case law, if you don't understand case postures, if you don't understand the substance of a case, if you don't know how to make the application and the reasoning in that case apply to your case, you verifying it still means nothing. There's so many nuances to court and the little things that you got to understand. And those little things are pretty much instinctive. It's like you just know what to do. It's like you probably don't know what you got to do right now, but as soon as that moment arrives, you already know what to do. Like the nuances. You can't plan for 1,000 different things, but it's like you'll be able to, you'll just know when that moment hits what you got to do. That's years of experience in court. So for him, there is no excuses.
AI, and hold on. No, sorry. Do not interrupt me, counsel. Do not attempt to come to me today and try to justify putting false information, false case law before the court, whether it's before me or Judge Burgess or anyone else. Don't do that. I just need to know.
Understood.
The basis for even having this go on further, because the sanction issue is real. Okay? I'm definitely considering sanctions. I don't think it's appropriate that you come now today now saying, well, yeah, that was incorrect. I didn't do it right. That is a fundamental issue for lawyers. I mean, the public's trust in the justice system.
Exactly. It should have never happened. No excuses. Pro se litigants, I can understand. If y'all did, I get it. You're not lawyers, you don't know. But as a lawyer, that is a unspoken rule. As a licensed attorney, you are never supposed to cite any case that's invalid, misstated, wrong numbers. You are never supposed to do it. There's no excuses for it. You know how we always got excuses like, well, there is no excuses for it. It is a must that you do that. I even know that under every 50 states, I got the code of ethics, professional ethics for lawyers. I even know that in all 50 states, federal circuits, state and local judges, civil attorneys, insurance attorneys, corporate attorney, any attorney. That is the bare minimum that you have to knock out the park. Ace, Poon Coon 100. Now, the court may disagree with a lawyer's interpretation of a case. Now it goes back, and that's not a sanction. But actually citing it and misciting a case, putting a case that don't exist, this is a lawyer and lawyers across America, and this is what I'm saying. I know it's run rampant in the pro se space. Lawyers across America are taking shortcuts and earning their money. Lawyers are using AI to do all the dirty work for them. They're not putting the legwork, the real it's hell to the no.
Is that the lawyers will do the information. It's a fundamental issue for lawyers. I mean, the public's trust in the justice system is that the lawyers will dutifully provide case information, court precedent, and cite it correctly. That
yes, sir.
You understand that. And so it's very difficult for me to stand here today and listen to this and not think that the sanctions should be very severe to you.
I understand,
you may continue,
Judge.
okay?
Thank you, Judge. I'm not going to minimize it. I started out the conversation by saying I'm not going to minimize it, and I'm sorry that it came across that way. That was not my intent.
I'm going to do this. One, I'm going to vacate the prior summary judgment rejection by the court. I'm not striking pleadings. I'm going to order all attorney's fees incurred by the defendants to have their hearing on the motion for summary judgment, not the preparation of it. Not the first one anyway. They're not going to need to be reimbursed for that. But I do need the attorney's fees incurred from the hearing date itself, because before that hearing, y'all gave him an opportunity to clean it up. So I'm not going to incur that. I'm not going to charge them.
And then they sent him a private email as a professional courtesy. They didn't even bring it to the courts first, because even though they're on different sides of the fields, they're still attorneys. They are part of the same like organization. So let's just say, like, if it was an attorney respond to a brief and I caught it, to be honest with you, I probably would have sent the email to him like, yo, email say, hey man, you sure this is the case you're relying on? This we don't weren't able to find it. Can you send me another case so I can accurately respond to you? I wouldn't just run directly, hey, Your Honor, look what they did wrong, because it's pretty like it's called professional courtesy. Like, now, before I take this to the court, hold on, we got him soon, but let's just give him a chance to get it right. Because once again, I've had to do my own negotiations, my own settlements with another attorney. So I understand professional courtesy. I understand being professional, even as pro se. I know I understand it. So I'm not looking at it like I'm just trying to bear it, but I would have did the same thing. Seek some type of, hey, before I respond to this, you got any more? Because this ain't it. Because I thoroughly research every case the other side cites. I thoroughly checked the case. Anything that they put on the arguments, and that's another thing in the pro se space. Many people, when they respond to attorneys' response to them, they're more likely to respond emotionally and respond to just what the attorney's saying. They're not responding to the case law. They're not looking at the reasoning in that case. They're not trying to find distinctions between the situation at hand and what the opposing attorney cited for. You get what I'm saying? They're just reacting to the complaint instead of actually, or the motion filed by the other side, instead of responding to it. They more likely are going to react to it. And if the other side says that their claims are wholly without merit, that's where you see the response is just 100% emotional. But it's the fact of the matter is, they gave him an opportunity to get it right before they put him on blast in court. So they gave him the professional courtesy, and he doubled down and still got it wrong. And he used ChatGPT or whatever thing to fabricate these cases, and this is what the hallucination gets you.
Those fees or assess those fees, but the fees incurred for the hearing itself and the subsequent hearing prep for the hearing today, the instrument to file, and today's hearing, those fees need to be put into an affidavit. I'm going to award those fees, assuming they're reasonable and necessary. I'm going to have y'all have another rehearing on the motion for summary judgment. So we're going to reset it. I'm striking the response to the summary judgment that was filed by the plaintiff. I'm going to reprimand counsel, Mr. Lee, for utilizing AI and not actually researching any citations that were submitted to the court. For the response to the summary judgment motion, every single case you cite, sir, you shall include either a link to it electronically or the physical copy to both the opposing counsel and to the court.
Damn. They make him go overdrive. So he can't just put the citation on there, because normally all you need the citation and you can look it up. He's making up provide the link and or an actual copy of the case. That's more work. But here's the thing. If that judge, all the courts of the United States of America came with that rule, that all you got to, if you were citing a case, you got to provide the case and you got to provide the link. With your arguments to support it, a lot of pro se litigants will be lost in the sauce, because they will have very few cases to support the arguments, the securitization arguments, the unjust enrichment arguments, the lawful tender of performance of the certificated arguments. You notice how it's never uncommon when you see pro se litigants and they file their complaints or they respond to a motion and there's just no case law, nothing. It's all, this is what happened. This is what I believe happened. And this is how wrong they are. And this is how they violate the statute. You notice how arguments that you hear online that's never really supported by case law. Like, you notice that, right? You ever notice that There's no case law that these teachers will hold up to support 100% everything that they're teaching, like this discharge package. You notice they'll never find no authority to support that discharge packet, that discharge template. Yo, go get this template for $20. You notice they never got no binding authority that's legally recognized, verifiable, or case law to support the packages that they selling. Oh, let me guess, administratively. Because they think administrative is the end of the game, that you never have to go to court. Like, you're going to resolve everything administratively. Well, what happens when they don't respond to your discharge packet? What if they do respond saying that's not valid payment under the contract, your account remains due? What do you do then? And this is where you get the opportunity to secure affidavit of non-performance, affidavit of non-response. Hey, you got 10 days to cure. You got 10 days to cure. You got 10 days to cure. Now I'm taking you to court on a legal theory that has no merit. And that's the cycle of these spaces.
If you cite any case, they have to be provided.
Understood.
For this reply. And I want it highlighted. Hold on. And if you're going to do any quotations, they need to be in your response. They've got to be highlighted in the actual text of the case law. But don't ever do this again.
Yeah, Judge, never happen again. One thing that I do want to preview for you is, they're saying it's an orange. I'm saying it's an apple. They're claiming.
Please stop it. Please stop. Just respond. I don't need to hear that now.
I guess let me hear from plaintiffs if you are still planning to proceed on your request for default.
Yes, Your Honor.
Okay. Did you receive the defendant's answers and affirmative defenses?
Yes, I did.
Okay. So then go ahead with your reason.
This is a pro se litigant now. Pro se.
Need for requesting default.
Okay, Your Honor, defendants claim they lack proper notice under CR 55A3. Their own Exhibit 3 directly refutes that. It contains the June 20th email notice I sent. Due to the logistics of obtaining estimates and bids, I will need approximately 2 months to complete the damages evaluation. Thank you, Your Honor.
What are you reading from, Mr. Walton?
And you know what? I swear to God, I knew when I first heard him start talking, it's an AI script. It was a script. It sounds, bro. It sounds like it. It sounds like it. Let's go back and hear it again. It sounds like it.
Just respond. I don't need to hear that now.
I guess let me hear from plaintiffs if you are still planning to proceed on your request for default.
Yes, Your Honor.
Okay. Did you receive the defendant's answers and affirmative defenses?
Yes, I did.
Okay. So then go ahead with your reasoning for requesting default.
Okay, Your Honor, defendants claim they lack proper notice under CR 55A3. Their own Exhibit 3 directly refutes that.
Right there. Right there. You see how he's it doesn't sound like human talk. It's very scripted.
It contains the June 20th email notice I sent. Due to the logistics of obtaining estimates and bids, I will need approximately 2 months to complete the damages evaluation. Thank you, Your Honor.
Right there. That's a chat GPT talk. It's a chat GPT talk. Right there.
What are you reading from, Mr. Walton?
And he's on audio. Yeah, he's on audio. It's 3 people on the screen. The one that was just talking, he's on audio. He's not even on video. And she asked that question.
Thing that I prepared for this hearing.
Okay. How did you prepare it?
By putting everything together.
And how did you put everything together?
By reading all the documents, all the filings. I spent hours putting together dates. It took me probably about 3 hours to get this prepared. Make sure it was edited so it wasn't too long.
What sources did you use?
The documents and research, RCW 2.44, the court rules.
What type
I've been
of?
involved in numerous lawsuits, so I'm familiar with how to research and look up case law and things like that. But my position right now is that
she doesn't buy it. She doesn't buy it. Not saying you ain't been familiar with lawsuits, not in case of research. I just don't think she's buying it.
they are in default. They didn't file a valid answer. According to CR 11, every pleading must be signed by the attorney of record, and that simply didn't happen. The lawyers,
Thank you. Yep. Thank you, Mr. Walton. I appreciate it. All right. For defense, I don't know who wants to take the lead.
I will start, and then perhaps Mr. Conroy can address the answer, the second answer. I mean, we're here, Your Honor, because for no good reason, right? As the court is astutely aware, the answer has been filed. It was filed on June 25th. Every other argument Mr. Walton has made to this court, presented to this court, violates CR 11, and reflects a profound misunderstanding of the rules.
There you go. There you go. That's the social media. I've been in lawsuits. I filed 50 lawsuits. I know what's going on. Yeah, all you got to do is come on there and go in there. Yeah, challenge the business records. Yeah, file your motion to limit it. Yeah, I've been in lawsuits. I know. Don't know jack shit. Read their fucking complaints. Don't know jack shit. No judgments on the record for them. No settlement, no nothing. All these, I've been in lawsuits. I've been in so many freaking lawsuits. I've been in lawsuits, so many 50. No, jack shit. Put their ass under that legal lens. See, they only come on the line to tell you what they want you to hear. Put their ass under the gun in that courtroom. It's a different ball game. It sound good when you just filing motions for people and typing motions. Put your ass in front of that judge and argue your case.
And then perhaps Mr. Conroy can address the answer, the second answer. I mean, we're here, Your Honor, because for no good reason, right? As the court is astutely aware, the answer has been filed. It was filed on June 25th. Every other argument Mr. Walton has made to this court, presented to this court, violates CR 11.
You notice how he's talking? You could tell, even though he's attorney talking, you could tell that he's not reading from a script. Like he already has the understanding of court. He already understands the rules that's been violated. You notice how when he's arguing his case, he can still talk and still talk robotic. See how the pro se, the first one, he was sounding robotic in his talk. Notice how he's very familiar, very calmly, very just going with it. That's the thing. Y'all be sounding too robotic in your responses, too robotic in court.
And reflects a profound misunderstanding of the rules. It is parties who appear in litigation, not lawyers.
There you go. Told you. But he's been in a lot of, I told you, these online, I've been in all these lawsuits, legal beagles. They don't even get the fundamentals down pat. That's why there's always 5,000 different amended complaints that they got to file. You notice that? All these virtuous legal beagles, it's always 50,000 amended complaints that they got to file. You notice how it's never one complaint that they have to file, and that one initial complaint is good enough to get the ball rolling and we move. You notice how it's always a second amended complaint, a third amended complaint, a fourth amended complaint. It's always the same sequence. File your complaint, get it dismissed before the other side is even ordered to respond. Bam! Within a week of the order coming down, they got to save face online, so they file a new complaint. So now it's, oh, the case ain't over. It's still pending. No, it's pending now because you filed a second amended complaint. Oh, that gets dismissed on the judge's own frivolity determination. What do? They go file a third one. Oh, no, the case ain't over. It's still pending. The hell out of here. You can fool everybody else that wants to believe the stuff that you're saying is true. You cannot fool the new culture empire. Because I'm around too many professionals who do this shit in real life. and my own real life experiences of being inside courtrooms. Absolutely not.
Parties appear, lawyers do it on behalf of parties. Once the party has appeared, they have to be given the notice. The fact that Mr. Volovovic or my office subsequently associated on behalf of these clients does not change the validity of the answers that have been filed. There is absolutely no legitimate reason we should be here. How Mr. Rosenberg and how those first cases that on the docket this afternoon, that's how this situation is supposed to be handled. The fact that Mr. Walton...
1 second. Hold on, y'all. Shout out to the GOAT. Shout out to the Hearts. Shout out to No Caps. Yes, sir. Y'all get like the No Caps and send the GOAT, send the Heart, send the fire thing. Hey, what's that one thing where the person come down from the sky and it's the shield and the knife hits the ground and it just kills everybody? Whatever it is, that should look cool. Tap the screen, hit the screen, share the screen, do whatever you gotta do.
Has ChatGPT or may have it on behalf of parties. Once the party has appeared, they have to be given the notice. The fact that Mr. Volovovic or my office subsequently associated on behalf of these clients does not change the validity of the answers that have been filed. There is absolutely no legitimate reason we should be here. How Mr. Rosenberg and how those first cases that on the docket this afternoon, that's how this situation is supposed to be handled.
And the judge is shaking their head like, I totally agree. And this is the problem with pro se legal beagles who thinks they were smarter than what they really are, who thinks they know more about court than what they really do. Just because they file 50,000 lawsuits a year and lose every single one of them, gets their case always dismissed for failure to state a claim. That means that's real life. But online, they're the lawsuit experts because they file 50 frivolous lawsuits a year. And none of them go nowhere. But come on the panel, as soon as they hit the panel, they always want to tell you what to do or how to do it.
The fact that Mr. Walton has ChatGPT or may have ChatGPT and has read it and doesn't understand the rules isn't a defense here. There is no good reason why my client should have had to pay to be at this hearing. The answer was filed by an attorney of record back the day after he filed his motion. Had he sent an email and provided the notice before filing the motion saying, hey, if you don't give me your answer, I'm going to file a motion for default, we would have said, oh, geez, here's the answer.
See, you want to know what that's called? Professional courtesy. Remember, pro se doesn't mean I don't have to know how it works between lawyers. That's why lawyers hate dealing with pro se litigants. Y'all are unprofessional. You don't know how to communicate with them on professional terms, on professional levels, to send professional courtesies. Some things you don't always have to go and slam it on a record. Some things you can send to them in an email. Classic example. I would have done the same thing. Hey, I noticed that you haven't responded before I send this motion for default, and just giving you a heads up that I will be filing the attached motion if response to that due. So I'm just giving you the heads up. That's what I did. I always gave them a heads up. Hey, I'm preparing to file this motion here. Here's a copy of it. Hey, I'm preparing to do this. Oh, why are you preparing? Listen. Once it gets filed on the record, they're going to respond anyway. There's no blindside or surprises in court. Well, except for that Scud missile that we dropped on Lakeview.
So instead he files the motion. We say, hey, here's your answer. Please strike your motion. And then we get these meritless arguments.
That's the problem. That's the problem. They don't know when to hold back. If they got the answer, classic example. As soon as I spoke to their attorney, CAC's attorney, I immediately moved for a motion to withdraw a pleading I filed. Here's a copy, y'all. Hey, storming out. I ain't gonna be able to get to the courthouse. Maybe I get there Monday. But here's y'all copy so y'all know that I ain't trying to be on some other stuff with y'all. Y'all ready to email? Thank you. We appreciate your good faith shown through that filing. We appreciate. Yeah. Nah, I'll get the. I'll strike it. That's professional courtesy. That's what any attorney would have done. Oh yeah, y'all responded. Oh, all right, come on. I'll remove. That's all right. They about to make an appearance. Hey, Your Honor, don't worry about that motion I filed. We good. Nope, not in the pro se space. I'm telling you, they think they understand court rules. They think they understand how proceedings go. They think they understand the orderly fashion of court. These fucking legal beagles, they think they understand how court works. They have no damn clue. I filed many lawsuits before. I know you don't know how it works. Sorry.
So instead he files the motion. We say, hey, here's your answer. Please strike your motion. And then we get these meritless arguments that reflect a profound misunderstanding of the rules. The court is well aware he is supposed to be held to the same standard as an attorney. The fact that he is pro se doesn't excuse this. I gave him plenty of warning that I would be asking for sanctions if he didn't strike this here.
There you go. Y'all think that those people think that just because you put it on a paper that it has merit, just because you type it up that it's legit. It is meritless. You can't flood the courts with meritless complaints after complaints after complaints. The other side has to respond to that meritless complaints. And then you may get slapped with sanctions. See, what they don't want to tell you is a lot of these pro se litigants in these spaces are getting hit with sanctions. There was one guy on Facebook who tied a UCC 1-308 group lawsuit, and he got hit for sanctions. He didn't know I was going to pull up well, he posted it, and he got hit with sanctions. Actually, he posted it. Hey, look, they trying to silence me. A Rule 11 sanction telling his group they're trying to silence him. But if you look at his complaint, it was flooded with sovereign citizen rhetoric. Told you, whenever the courts reject these beliefs with reality, it's always like they treat them like they're Edward Snowden. Like they make themselves like they're some fucking martyr. Oh, they're trying to silence me. They don't want the truth out. They don't want the truth to be exposed. Let me ask yourself this question. Why can't it be that maybe they're asking for sanctions because these are sanctionable offenses under Rule 11? Why can't that ever be a doubt, or not a doubt, or something that just creeps in their mind? Why can't that may be the answer as well? Oh, no, it can't be that. I got too many people that I'm teaching in this group for that not to be right. Right.
And he has refused. He should be sanctioned. This type of behavior should not be tolerated. None of us need to be here right now.
Mr. Conway, go ahead.
Yes, Your Honor, nothing too much to add. We have, and I know that this is probably the first the court has heard on this, but there has been a long, tiring history of AI, appeared to be AI-generated motions and responses and challenges to everything. And most of what we do is met with, threats of CR11 sanctions. And we did get the answer in, and Mr. Mooney did, and I think he included the emails, but he did remind Mr. Walton several times of the rules here and how much it would cost us to come in and sit on this docket. I've now been here almost an hour.
Mr. Walton, anything briefly further that you want me to know?
Yes, Your Honor. As far as their arguments, the rules are the rules. I don't know why they keep misstating the rules. I'm not required to serve them notice before filing a motion. The plain language says 5 days before the hearing. So I don't know where that's even coming from. But first, CR 55A3 notice was fully satisfied. Their own Exhibit 3 shows that my June 20 email with the motion blah, 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 was received, given 25 days notice. Second, appearance is undisputed. Mr. Conway appeared for all defendants on April 13th and never withdrew. No other attorney filed a notice of appearance. A notice of association is not the same as a notice of appearance. It's right there in the rules. It's pretty basic. Third, none of the answers are valid under CR 11 or RCW 2.44 because none bear Mr. Conway's signature. Finally, no valid answer to the First Amendment complaint was filed by the June 11th deadline. These arguments about that I'm required because other attorneys withdrew their motion and all this nonsense about frivolous misunderstanding the rules. I know how to read, Your Honor. Apparently, I don't know why they are. It seems to be purposely misleading, trying to mislead the court.
Okay. So
regardless of today's argument.
And everything that you're wholeheartedly, you're wrong. You're wrong. It's not how it goes. You're wrong. Yes, everything, all your years of study, you're wrong. It's not how it goes. Sorry.
Yes. The procedural posture is unchanged. Notice was proper. Appearances are clear. Signatures are missing, and no valid answer exists. Default is appropriate. And I find it very insulting, this AI stuff. He's accusing me that I didn't write this stuff when I did. If you look through my whole history with this court, I mean, before AI was even a thing, you can see that I'm consistent. I read the rules, I read the law, and
Right, but your interpretation of them is still off. That's the classic. All you got to do is just read Civil Rules 26. Just read this statute. Just read. That's all you got to do. And your as soon as you read it, you're going to have the interpretations, how the court see it. You're going to have multiple cases already in your brain that that rule was applied to, or you're going to have all the updates and the amendments to the rules. You're going to have all the procedures and how the rule is implemented. Oh, you're going to know all that just by reading the statute, reading a broad rule of civil procedure. All you got to do is just read it. That's all you need to do is just read it. Oh, now you got to comprehend it. Well, how you going to comprehend? You're going to use your own comprehension, or you're going to use the consensus of the court's comprehension. So they try to simplify the technical, nuance, itty bitty, teeny little things that means the most in court. No, you just simplify it by just read it. Of course.
Except for right now being accused of what they're accusing me of, it's kind of frustrating. But with that, I'll leave it to the court. Thank you.
Yeah, so the reason that I called this case at the time that I did, Mr. Walton, was that I was hopeful that you would see the other cases that were on for default that frankly were in very similar position, and actually probably a worse off position than yours, because there was an answer filed and then by one attorney, and then there's an answer filed by another after notices of association of counsel.
AKA, she was trying to get you to withdraw. That's why she wanted you to sit and see everything else. Once again, you can read the rules, you can read the plain letter of the rule, but you don't know how the procedure goes in court. Procedures are governed by rules. We get that, but you don't understand the nuances on how the court does things. If they filed an answer, if it's a day late, whatever, strike your motion for default, because that's what professional lawyers do. Pro se. You're trying to force a default on them, and the courts are not going to allow it. That's pro se litigants for you. Oh, they late about 1 day. All right, default, you're on a default. Oh, I asked them for 75 things and a notice of error or arrest report. They were 1 day they responded and filed a lawsuit. $1,000 per unanswered question. Let me go get the lawsuit on now. Y'all have no goddamn foresight, no insight, no professionalism. And this is what happens when you use the court systems to chase money. Until it blows up in your face, it gets dismissed. Now you're mad at the world. When you say you are pro se, You are representing to yourself, to the courts, that you're going to conduct your manner in a way as all other attorneys do. That's what it means when you say you're pro se. But you rarely ever see it. Ever.
And case law is very clear that if you show up to this hearing, you're requesting default and an answer has been filed, the court's going to deny it. So I am denying your motion.
Told you. What was all this? The case law is very clear. I know how to read case law. I've been doing lawsuits for I've been very consistent. I know how to read case law. See what happens when he read the rules? See the difference? See, he read the rules. And you see what happened? He read the rules. I read the rules. And the rules were real clear. Real clear. They filed an answer already. You dingbat. Oh, yeah.
Of counsel. And at the time that I did, Mr. Walton, was that I was hopeful that you would see the other cases that were on for default that frankly were in very similar position, and actually probably a worse off position than yours, because there was an answer filed and then by one attorney, and then there's an answer filed by another after notices of association.
Yes, pro se is a temporary law license. It's pretty much
of counsel. And case law is very clear that if you show up to this hearing, you're requesting default and an answer has been filed, the court's going to deny it. So I am denying your motion for default.
I would have told you to put a motion in to withdraw. They showed up, they had filed the answer. Bro, withdraw. The judges, you were a day late. You're just splitting hairs on the wrong things. You're splitting hairs on the wrong things. You notice how y'all be so technical to try to get every little thing. Let me get them. But to let them get technical with you. Pro se, it's not fair. Be careful trying to be an aggressive litigator against these lawyers, and you're not really an aggressive litigator. Be careful trying to come at them aggressive like you really about that life. They really about to dog pound on you. They really about to dog pound. They're gonna have about 3 or 4 attorneys, partners at that laws working on this stuff. You're lucky you just got one working on it. Try to act like you're aggressive. They're gonna have about 3 or 4 professional eyes to your one. Oh yeah, they're gonna dog pile on you.
It is not grounded in the facts of this case. There are proper been filed. So I am denying your motion for default. It is not grounded in the facts of this case. There are proper answers that have been filed to the amended complaint. So I'm having a hard time following your logic as to trying to parse out who signed what when. By all accounts, the attorneys, when they filed their answers, have indicated who their clients are. So
typical wasting time on frivolous, non-important, nothing burger arguments. Who signed this? What's the signature? Signature's not dated. It's not this. Who did it? All nothing burger arguments. It means nothing. You think it means something, but it means nothing. See? We wouldn't even had this hearing. No, wouldn't be no need for it.
There's simply no grounds for default. Again, the reason I called this case when I did was I was hopeful that when I came to you, Mr. Walton, you would acknowledge to the court that answers have been filed and you were striking this request.
And you know what? If I was giving him advice, I'd have told him, tell the court you want to withdraw or strike this request now that the other parties filed. No, she's going to deny it, bro. Like, they're already here. They're on the record. Like, come on, man. That it seems like, no, you're going to get further down the line. You want to know why? Because I know that professional courtesy, understanding how court works, when he would have struck that motion, the courts would have took him seriously, like he understands courts and understand how court works and understands the rules and understands how it goes. That means you're going to be, Your claims are going to be taken more credible. It's nothing frustrating than a professional attorney than dealing with a headstrong, hard-headed, pro se litigants that thinks they know everything under the sun, but every time they put it on paper, they're always getting it wrong. It is so frustrating dealing with those type of pro se litigants. They always get it wrong on paper, but they'll tell you how much they know. Of course.
Because that hasn't happened, I am required to deny your request. And I am going to grant CR 11 sanctions for the attorneys having to be here and argue against default.
Damn. You got sanctioned. This is that. I've been doing this, filing lawsuits forever. Can you imagine how those lawsuits turned out? You got sanctioned by your own stubbornness, thinking you know more about court, how it works, and you really got sanctioned because you failed to show professional courtesy. Now you got sanctioned.
Okay.
This filing was a serious mistake. My clients apologized to the court, to opposing counsel and their clients, and certainly to their own client.
Law clerk used ChatGPT to draft the court filing, and it hallucinated bogus cases. The attorneys filed it without checking, got caught, then hired this attorney for today's sanction hearing.
They are embarrassed about this. They are disappointed in themselves and in the failure of their normal process that led to the filing of this petition. I don't know how much you want to hear from me up front, but I'd like to explain what we think happened here and what the firm has done to measures it's taken to make sure it doesn't happen again. And if I may, I'd like to add a little bit of background about Mr. DeBano and Mr. Bednar that leads up to the filing of the petition. What happened here was that Richard asked a law clerk in their office to prepare the initial draft of this petition. Richard then did some work on it, and he and the law clerk exchanged drafts back and forth as those things go. And ultimately it was filed. He did ask that those case citations be checked and later learned that didn't happen. But Richard did not do that himself. He does not point fingers at others. I'm simply trying to add context. He takes responsibility for this. He is the licensed lawyer who signed the petition and it was filed with the court.
So do I infer then that it was the law clerk who used ChatGPT to generate some portion of the filing?
Yes, that's correct. That's correct.
Is the law clerk licensed to practice law?
No.
Oh my God. Oh my fucking God, man. What a travesty. And they had to hire this lawyer. He just playing damage control and character control. This is bad. This is really bad. This is really, really, really bad. Yeah. He can only do but so much. This is horrible. Oh my gosh, I feel for him. Golly, this is bad.
No, and that's why I say Richard takes responsibility. He's the one who is licensed. They work together on the document, of course, but ultimately the lawyer who signs and files it is the one responsible. We all know that. And Richard's not trying to hide from that responsibility today. I'm happy to.
Was Mr. Bednar aware that ChatGPT was being used to draft the petition?
No, he was not. And thank you for.
Wow. So your law clerk, who's not licensed, they just held to help draft, use ChatGPT. Oh my, that is the last thing that you want to have drafting your complaint through and through. That is the last thing. Not through and through.
For that question. I began by saying this was a serious mistake, and it was. but it was a mistake. It was not knowing. I don't believe it even satisfies the standard for recklessness. He did not know that AI had been used to generate anything in connection with the brief until after the fact, when they went back to try and reconstruct what had happened here, and then learned that yes, it had been.
And were there any conversations at any point prior to this brief being drafted about the use of AI in their practice and at their firm by this law clerk or any other employees?
To my knowledge, no. I don't think I've asked that specific question. But I've certainly asked that question about, going forward, and that AI was used. We acknowledge that in the generation, but I don't believe that Richard or Doug knew that in the drafting stage before it was filed.
And I'm asking more generally, did the firm have a policy, maybe something less formal than a policy for their employees about using AI or ChatGPT to generate work product?
I don't believe so.
ChatGPT is killing it, ain't he? The owners, boy, they crushing it. ChatGPT is the go-to for pretty much anything.
And I can stop to ask my clients specifically if you would like, but we've had a number of discussions and they haven't mentioned that to me, so I don't believe that was any kind of a policy. I can tell you there is a policy now. I think there is a place in the world for AI, but it certainly isn't the place to write your brief for you and find your cases for you. We acknowledge that.
I'm telling you, you still gotta put human eyes on it. You still gotta put human eyes on it. Even with your case citation. What about the synopsis? How do you know if the synopsis even lines up? Like, you got to understand, man.
Well, I don't think it's the position of the court that AI isn't a tool that can be used by lawyers and whatever assistance it may provide. I think the concern we have is obviously that in this case.
Yes, no court is saying that you can't use it. No court saying it. Basically, courts are saying, regardless if you use AI or not, whoever's signature is going on it, the certification, I certify that all the foregoing are true and correct. It's the person who's filing it signature. It's them who is responsible for verifying it. It's them who has to ensure that it's legit, because simply as put, if you're not a licensed attorney and you're not doing the verification signature subject to sanctions and you're helping people with court, the reality is any errors, any omissions, any recklessness, any confirmation bias belief theories that you are given, preparing, typing for the other party to file, for your client to file, anything that goes wrong, the client bears the burden. The client feels the pain. The client suffers the consequences. That's why you have to be extremely careful on who you help draft your complaints. You got to be very cautious, because if they don't even understand the basics of court and they're just running this fake, I know how to help, and they just running your shit through ChatGPT and spitting out the responses, if a case is cited that's inaccurate, the client, you're going to pay for that shit.
Case, ChatGPT hallucinated at least one case and probably cited other cases for propositions that were unrelated to those cases in their holdings, and a lawyer didn't check that, right?
That's the problem. A licensed attorney didn't check it. That's the problem, because it doesn't matter. It's a known thing in the attorney's world. You always check the case filing. You check the citation. You check the numbers. You always check it. You always verify it. What the fuck is wrong with these law firms?
right? We as attorneys, as you've said, when we sign documents for filing with the court, we're making a representation under the rules about the veracity of the information contained in whatever the document is that we're filing, and that's a responsibility we bear. So while AAI is certainly a tool that people appear to be using successfully, here it obviously was unsuccessful, and there apparently wasn't an effort made to double check it. And that's really the concern, I think, for this court, is that there was a failing on the role of the attorney to make sure that what was being presented to the court was in fact accurate.
Well, and it implicates, in my mind at least, the duty of candor to the tribunal. Yes. Here is this case, and it supports our position, and the case doesn't exist.
Embarrassing. 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 Submitted something that even just your local clerk drew up, if he even thought that is still pretty. Wild if he didn't review it first. He didn't even review it. That is embarrassing. The case didn't even exist. Oh my God. That's ChatGPT for you. You don't think they'll cite cases that got you thinking, oh yeah, I got him. Go look up the case, put the citations in, put it in the search and put it in Justy and put it in West. They'll be like, huh? This case don't exist.
That moves it in my mind beyond a mere error. An error would be it's the wrong pin site. We didn't realize the case was later overruled by the Utah Supreme Court.
Yeah, oh yeah, understanding that. Oh shit, it was overruled later. Oh, okay. Or they'll even let, instead of putting 485 US, you put it 484 US. That could have been a typo. You just type in it, you didn't catch it because you see the 484. It could have been. There's been plenty of times where I'm typing a case and when I'm going through, I look, I said, oh no, I put a 481, it's supposed to be a 482 right there. Yeah, because I gotta check the citations. But those little typo errors, this case didn't even exist at all. It kills your whole argument. That's the whole thing. Now, if the judge would have made an order or ruling off that, you see how crazy it looks now? Oh my God.
There are, I was going to say 1,000, that's an exaggeration. There are a bunch of cases in Utah called State versus Carter. Quite by accident, we cited the wrong State versus Carter. That's our error. It doesn't really support the proposition, but where you have a case that's non-existent and represent to the court by signature that this is valid authority, that's a more serious problem in my mind than a mere error.
Facts. And guess what? No, the other courts, if let's say that was the former was the issue, the latter was the issue, you probably wouldn't get sanctioned for it. You probably wouldn't get in trouble for it. It's just a little error, like an error in the citation or something. Or the court was overruled. The court would be like, yes, such and such cited this, but however, this case has been overruled by this. Cool. It is what it is, a little error. But when it doesn't even exist, that's horrible. That is horrible.
Understood. I hear what you're saying, and I do think that the court needs to look at this as to what Mr. Bednar knew at the time the petition was filed.
AKA incorrectly throwing the law clerk under the bus without actually throwing the law clerk under the bus, without actually wording it like the lawyer is trying to escape accountability because he signed the certificate. So now he has to play inside of that little box. Basically, what he actually knew, throwing the law clerk under the bus without coming off as he shouldn't be sanctioned for nothing because he did sign it. Damn, they got the lawyer in a tight spot, boy. Woo-wee. And they hired, the law firm hired this counsel. Now ask yourself, why would the law firm hire a counsel when they have counsels at the law firm? Because Abraham Lincoln said, he who represents himself has a full client. I know in all cases that may not be true. My case is one of those, but that's the normal consensus. Lawyers even hire other lawyers to represent them. That's kind of what it is, though.
He did not know, and by imposition of duty, he should have known. We acknowledge that Royer versus Nelson is a non-existent case. It actually exists in Indiana as a table citation. There's no content to it. It is a fake citation.
Oh my God! You had a fake site. Oh, man, that's the problem, law firms. Y'all keep going with these fucking cheap ass little law clerks. Yeah, you should have got one of us. We would have spotted it out. We would have spotted out that none of this shit exists. And we'd have taxed you for it. We would have caught it before it was filed. You professional license. Sometimes I come back to bite you in the ass.
But it was never intended to be that way. And that's the point I emphasize today, is what was in the mind of Mr. Bednar at that moment. I will say, harking to a part of Rule 3.3, they have filed a request for leave to file an amended petition, in part, of course, to protect their client from the effects of this initial petition, but in part to correct the misstatements in the original one. That's one of the requirements in Rule 3.3, and they have done that. Now, what the court does with that request is not within the scope of my representation, but I point that out.
Nor really within the scope of the hearing, but we're mindful of the.
Yes.
Let me ask.
Has absolutely two jack shits, nothing to do with it. But it's a good legal thing, but has nothing to do with it. This is a sanctions hearing.
This is the client, Mr. Gardner, aware of the order to show cause and order and the hearing that was set today?
Yes, and I believe he's here. Mr. Gardner is
Mr.
here.
Gardner, all right, thank you.
That has been disclosed to him fully. It was not a pleasant phone call for them to make to their client, as you might imagine.
That would have been a phone call that I would have dreaded. That would have been a phone call that I would have dreaded. You mean to tell me I got to call this client and tell them that you cited cases that didn't even fucking exist? I knew I should have read that shit. God damn it. Because it falls back on me.
They have been completely upfront with them since learning of this, and have tried to be the same with the court through our presentation today. And I had a conversation with Mr. Salen last week to attempt to accomplish that same purpose. I'm prepared to go through each of these citations if you want to drill down to that level.
I don't think so.
But I will say, certainly the Royer versus Nelson case does not exist. The Westside Nursery and the Granite something construction case, they are real Utah cases, but they don't stand for the propositions for which they are cited. The Jones-Waldo case, I think, is appropriately represented in the petition. State versus Wilden, State versus Spry are also appropriately represented. They probably aren't on point ultimately, but I think as far as what's stated in the petition about those opinions, I believe that's correct. And I say that's my summary. I'm happy to address that further if you'd like. And I will say that I mentioned something earlier, but the firm has adopted a formal policy now about how they will handle the writing and the submission of any filing with the court, but in particular those that's.
Oh, so you ain't already supposed to have that? So it takes an embarrassment like this before you already make sure you're supposed to do what you already supposed to already know what you're supposed to be doing? You want to know why? Because your ass has been getting away with it, being cheap, taking all that money from clients up front just to slap AI, and you ain't get caught plenty of times. You probably got away with winning some cases or stuff like that using it. You got caught with your hands in the cookie jar now. Now you want to have a policy. hey, whoever the client is, hey, we got something for you. We won't make that rookie mistake, y'all. Whoever that client is, if you ever watching this, hey, sometimes it pays to have some non-licensed paralegal litigants to help you out. Because at least we know we'll never make that mistake. A goddamn law firm.
Cite case law. I'm happy to walk through that with you, just a 4-step process, but I want you to know that that is something that they have done. It's a small firm, but it is a formal policy.
Makes sense. Makes sense. Figured that.
See, now they don't ever want this to happen again. And an offer has been made. I know Mr. Salin and his clients have considered that. The offer is still open, and I think Greg and I can easily communicate about that more if they're interested. But the offer is to pay all of the legal expense incurred in responding to the initial petition. I suppose more if that is deemed to be warranted.
What would be your position about a monetary sanction above and beyond making the other side's attorneys whole in view of the misrepresentation to the court? I know around the country we've
Judge, you asked him a tough question. That was a very put you on the spot question. That is a very tough question. Because look how he's looking. You already know it warrants a monetary sanction. You want him to say it? Oh, yeah, Your Honor, my client. That was a very strategic question. The Judge Grimmett, you ain't shit for that question. You ain't shit for that question, Judge. Oh, shit.
We did a little research, and where this has come up before, this is not the first time it's happened in the country. This is happening all the damn time. Sanctions of
You hear that? It's happening all the time. It is the new phenomenon. It is the new phenomenon. Have AI cite your cases. AI draft your complaints for you. It's the new phenomenon. But what happens when you got to take your ass in open court and argue those cases? Whatever happens to you in open court?
$1,000 here, $5,000 there have been imposed by courts around the country, I guess, to sort of
make the point,
send the message more strongly than just making the other side whole would do. And I'd be interested in your position about the propriety of some such sanction in this case.
I think that's well within the scope of Rule 40 and what the court can do here. That's certainly not something my clients would love to hear, but they understand that is a potential outcome of the hearing today. Rule 40, is it C or D? I've forgotten. That I think gives the court fairly broad discretion in imposing sanctions.
And obviously neither that sanction nor the attorney's fees to be paid to the other side, those wouldn't fall to the client. The attorneys would be responsible for that personally. I assume there's no issue on that.
They would be responsible for the attorney fees for sure. They would not charge their client for that. The attorneys would pay those attorney's fees, and I assume the same would be true if the court imposed a monetary sanction as well. I don't think any of that.
They got insurance. It's what they licensing and bondings for. They got insurance for negligence, liability. They got insurance. The premiums might raise, but they got insurance. They'll be able to pay it. Law firms, they get insurance for this particular reason. They get insured for this particular reason. So, yeah.
Be passed on to a client, right? I guess I would. Sorry, Judge Oliver.
Yeah, I would just like to say, I think a concern I have in general, and this factors into at least my view of whether sanctions should be imposed and what amounts they should be, is that we had the benefit here of opposing counsel who pointed out to the court the use of citations that were hallucinations that didn't exist, and case citations that were incorrect as a proposition of law. We as a court system, as everyone knows, we're very busy. We have more work probably than we can do as quickly as we would prefer.
So when you're attaching 335 pages of an SEC filing and being like, here, judge, figure it out, they're not reading it. So you make 50-page ramblings, efficiency, judicial efficiency. Get to the point. Get to your point. 5,000 pages of what they did, what you did, what you sent, what notice, what they didn't do, ramblings about the elements of the cause of action, not necessarily stating the cause of action, making 5,000 legal conclusions before every period. It's a goddamn it. And because they did this, they violate the law. Oh, because they did this, they violated this. Because they did this, they violate that. Because they did that, they committed fraud. All bunch of legal conclusions with Bell Atlantic versus Twombly and Ashcroft versus has told you don't do. But what are you going to see in 98% of responses? The same thing the courts tell you not to do. There ain't been a goddamn case yet that I've read from a pro se litigant that doesn't have at least 3 legal conclusions. Legal conclusion. What's the legal conclusion? Go make one and hear the order. You'll know what a legal conclusion is in the judge's order. You'll know what it is.
And so it can't be that the judiciary is the backstop to double check and triple check every citation that's made in a filing that's presented to the court. We simply don't have the resources or the time to do that. And so what we do is we depend very much on the honor system of those attorneys who practice before us. And that is part of our rules, Rule 3.3, Rule 40, that when a document is presented to the court with a signature of a licensed attorney,
it's presumed to be 100% accurate. So there's no need for the courts to go double check and triple check with a licensed attorney. Exactly. So they're getting the benefit of the doubt because they're licensed attorneys against a pro se litigant. You know, when they be ignoring you, you ever know you request things from them, they just ignore you? They don't say nothing. They don't do nothing. They'll never do that with another licensed attorney. See, they respond back in email. Because some preliminary matters don't always have to take a fucking letter, a motion, a fucking 10-day demand, a fucking demand this, do this by this, do this by this, judicial default here, opportunity to cure. Some of that shit could be handled with a professional email. But if they had a licensed attorney, they probably would have got a response sooner. Pro se litigants, they could stall them out. And there's not really so much you can do when they stall you out. As long as they're a court deadline, but they can stall you out. Trust me. Pro se litigants, it takes a lot for any document to get escalated to compliance or get taken serious or get like, oh, respond back, respond to this. It takes a lot. Well, the reason I say it takes a lot, because the average pro se response is just filled with legal ramblings, financial buzzwords, apply the principles to the principles and the balance of the principles, and provide the accounting, the general term, provide the accounting, provide the statement that they did this, provide this, provide this, provide this, provide this, provide this, provide that.
That we can trust that what's being argued in there is being argued in good faith and based on real cases and case law, and is a valid and good argument for the extension of the law. And I think if this problem were to become more widespread, it's a larger problem for the judiciary and the integrity of the judicial system. And so I just want to say for the record,
this is why they're scrutinizing your legal documents even further. This is why they're going to be they're going to end up scrutinizing the documents to the T, the filings to the T. It's getting to the point where you damn near got to be a wizard to get a motion through the door now. It's getting there with this AI stuff, AI doing everything. And you have to be a goddamn wizard. Sooner or later with the court systems, you damn near got to be a damn wizard to get your motions through the door. I see it coming. I see it coming.
That this is something that we have grave concern about, and something that we need to make sure that attorneys have grave concern about, and that they make every effort to make sure that what they present to this court under their signature is accurate to the best of their abilities. We certainly understand that errors may occur, typographical errors, miscites and things of the nature that Judge Orm discussed. This is an entirely different category. And so that is why we called this hearing, which is quite unusual for the Court of Appeals to do. And so I say that just to explain why really we're here today. We take this matter very seriously on behalf of not only our court, but the entire Utah judiciary. And it's something that is very serious.
Absolutely. Thank you. And I confirm that my clients are committed to upholding the honor system that the court has just articulated. And they have learned that lesson in a very difficult way. And as I said, they come here embarrassed and disappointed and perhaps more firmly committed to make sure this never happens again than someone who hasn't been involved in this kind of a failure.
Well, attorney's fees. So he should pay the attorney's fees and respondents for the time spent responding to it. Petitioner's counsel shall refund petitioner all fees charged and paid for the filing of the petition, or they due within 7 days. And Mr. Brennan shall pay $1,000 form of a donation to the Justice for All within 14 days. So the petition, they refunded the petitioner for all fees charged, paid for filing a petition. They got to pay the attorney's fees for the respondents for spending time responding to the petition and attending the OSC hearing. And he got to pay $1,000 to a donation. That was fair. That was reasonable. They could have spanked him harder, but that was fair. It's becoming a problem. The prevalence and impact on conclusory pleadings, aka your average pro se litigant's response. Pro se complaints are overwhelmingly prone to include bald legal conclusions or speculation instead of specific factual allegations. Under Federal Rules of Procedure 12b-6, this triggers a high rate of dismissal for failure to state a claim. Because pro se litigants struggle to separate factual pleading from legal conclusions, their long-term success rate in federal court is remarkably low. Unrepresented plaintiffs win only about 3% of final judgments, compared to a much higher baseline for represented parties. I don't give a damn what you say, what you do. The success rate is still low. Very low. The liberal construction cushion. To counteract this exact problem, courts are required to use special solicitude when reading a pro se complaint. This means the judge will actively try to look past poorly phrased legal conclusions to extract any underlying facts that could salvage the case. The landscape of pro se filing is undergoing a massive shift due to artificial intelligence, which naturally formats arguments into clean-looking legal conclusions. Federal courts have reported that pro se filings bear clear markers of generative AI text surge from virtually 0 to over 18% of the total pro se document. No merit boost. Despite generative AI making pro se paperwork look more professional and structurally full of legal definitions, substantive win rates have not improved. The text often mimics a lawyer's style, but still lacks the vital case-specific factual foundation required by law. A business may hesitate to hire an attorney to formally respond to a pro se litigants' allegations because those allegations may seem informal or meritless. The complaint might be handwritten, allege fantastical conspiracies, or go on for page after page with little substance. But however, seemingly unofficial or meritless, a complaint that is properly filed and served cannot be ignored without risk of default, potential liability to the plaintiff. Now, instead of avoiding pro se complaints, businesses should address them head on. Such complaints might be subject to dismissal. For example, pro se litigant. This is how they telling you how to deal with pro se litigants. For example, pro se litigants often file complaints that do not meet legal pleading requirements or lack causable claims. Just like when a pro se litigant wants to sue for attorney's fees, like that is a meritless claim. No pro se litigant can get attorney's fees, especially you said there's stipulation of dismissal. And a normal legal stipulation of dismissal, each party bears their own costs and fees, or it may be stipulated that nobody bears the cost. But if you think that a person's going to take a pro se litigant serious, if they think that a pro se litigant is entitled to attorney's fees, that is a rookie assertion. Cannot pay a pro se attorney's fees when you're acting pro se. In federal court, a complaint must assert sufficient detailed factual matter to state a claim to relief that is plausible on its face. That is Ashcroft versus Bug. Shout out. Yes, sir. Quoted Bell Atlantic versus Twombly. Legal conclusions are couched as factual allegations, do not suffice, and a complaint must contain sufficient factual allegations to show more than a sheer possibility that the defendant has acted unlawfully. Many pro se complaints lack sufficient facts to state a claim for relief. Pro se litigants often rely instead on speculation or bald conclusions. While courts read pro se complaints with some degree of leniency, the pleading standards still apply, and complaints that are insufficiently pled are subject to dismissal. Example, Martinez versus Queens County District Attorney, a case in which Phillips Little was an attorney of record. The plaintiff alleged a violation of 1983, claiming that for several years, his ex-girlfriend, her relatives, and judges, prosecutors, family court attorneys, police departments, state agencies, healthcare providers, and telecommunications companies in New York and Pennsylvania conspired to injure him in various unconstitutional ways. Section 1983 provides a cause of action against only state actors or those who conspire with state actors. Telecommunications companies moved to dismiss the suit under Rule 12b-6 on the ground that plaintiff have failed to specify how they conspired with state actors. The district court agreed that plaintiff have failed to show the existence of any agreement or concerted action between telecoms and state actors and dismissed the suit. In pro se space, they'll send a discovery or an admission or interrogatories, admit that you and the state actors conspire together. Produce the agreement that you have with the state actors to conspire against me. It'd be stupid shit like that. The basis for the telecom defendant's successful motion on Martinez failure to state a claim upon which can be granted is one of the host of grounds that must be asserted before defendant answers the complaint. In federal court, defendants usually have 21 days to answer the complaint or make a pre-answer motion to dismiss. And in New York, it's between 20 and 30 days. Since pro se plaintiff's allegations are likely to be disorganized or muddled, It is all the more important for a business defendant to promptly retain an attorney who can review the complaint to determine whether to answer or make a pre-answer motion to dismiss the complaint. The time pressure is particularly heightened in a pro se case because while a defense attorney can often obtain an extension from time from the opposing counsel, it is more difficult to obtain extension from pro se litigants who may be unaware or unconcerned with the courtesies of the legal profession or simply unreachable, aka professional courtesy. How it goes. How it. Hey, Johnny, hey, we're gonna need an extension of 30 days, man. I'll put this motion in. You want to oppose to it? Yeah, I'm gonna oppose to it. All right, I'm gonna file it now. Hey, new coach, hey, we need about another 30 days to respond. You okay with that? Nah, I'm going ahead. You can tell them unopposed. You need me to sign something? Yeah, I'll send over to you to sign. All right, no worries. All right. Thank you, Miss Melissa. Nah, not in the pro se space. Everything is a attack mindset. Us against them. Conspiracy mindset. I'm telling you, the average pro se litigant has some shape, form, or fashion, a deep-rooted, sovereign citizen inkling in them. And I always see it the most in the ones who vehemently deny it. Who vehemently deny being a sovereign citizen. Those be the ones who really got the yin in them. Court, not court, anything in between. A lot of them have a sovereign citizen foundation. They just don't see it. That's all. They just don't see it. All right. So, I think that was good. That was good. So, YouTube, I'm going to catch you on the next one. Y'all, we're going to continue this over here on TikTok, YouTube, Facebook. I'm going to catch y'all on the next one. We're going to continue this discussion on the talk. And we will see y'all on the next one.